made with the Malada. I have some personal difficulty. I have to leave out of question. Item number 27. Can it be taken up next week?
Heard Mr. P.K. Roy Chaudhary, who praised for an attorney on the ground of his personal difficulty. Also heard Mr. B.B. Gopal an additional topic prosecution.
Yes.
Considering the grounds mentioned by the current counsel, the prayer is allowed.
For the interim order purpose.
Let this case be listed on. Speak.
29.
2911.
Madam,
2911.
29 interim order.
The interim order shall continue.
Oblige.
May please Lord, back to my item 30. 30. Kindly matter take that 2 year long.
Today
Yes.
at 2.
Yes. Oblige.
30
30.
তেওঁ আছে তোমালোকৰ অপোজিট সাইডত টাইম নাথাকে কথা পাতি লোৱা ঠিকেই আছে
May I pay a lot? I beg to mention for listening of a matter today, Lord. The urgency is that the matter in trial court is fixed on 70. And if witness is examined, then the matter will be become infractor. And tomorrow I have some difficulty. Therefore, I am praying today, Lord.
What matter?
That recalling of a witness, Lord, after closure of all evidences when the matter was fixed for argument.
Today, court is rising earlier because of it.
If time permits, if it comes soon, Lord, we will see. Oblige.
Take up item number 30 of Lordship.
Well, not today because he wants to have it on after 2 because I have some difficulty at 1.
Tuesday, your Lord.
Next Tuesday.
Heard Miss, what's your name?
S. Nazni, your Lordship.
S.
Nazni. My name
Yes.
is the positive
30
Learned counsel for the
petitioner.
petitioner. Also heard Mr. P.K. Roy Chaudhary. On request of learned counsel for both the sides, let this case be listed on
Tuesday. 21.
21/11.
Oblige.
Oblige.
Daily list motion B, item number 1.
Your Lordship, please. My Lord, hiring and for 1 page 9 matter. Here the letter in this case the 302 is added.
Is there
Letter added.
heard Mr. P. Upadhyay, learned counsel for the petitioner. Also heard Mr. B.B. Gopal, learned additional public prosecutor. The result of the case will be necessary for consideration of the instant bail application. Hence, call for the case.
They are already custody for more than 72 days already.
When you can call, bring
29/11 Haju
call for the case, then
Oblige.
let this case be fixed again on 29/11 for case.
Item number 2.
May I please, Your Lordship. This is a 439 application. Before I make any submission, Lordship, I would like to point out just two typographical mistake, Lordship, in the cost title. The date of arrest is 12/10, not 8/9.
Correct.
Yes, I will correct it, Lordship. So you may call for the case diary here. So correct can I correct? Can I correct? So you have to file the I
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. B.B. Gopal, learned additional public prosecutor. Learned counsel for the petitioner submits that there is a typographical mistake in the cause title of the bail application and prays for allowing the petitioner to make necessary corrections. The prayer is allowed. You have to follow the procedure.
I have to file a I interrogatory application.
Not you file the corrected cause title, printed cause,
Yes.
typed cause title. In the meanwhile, considering the nature of allegations leveled in the affair, let the case diary be called for. Fixing,
29 or 30. 30.
fixing 3011 for case diary.
Oblige.
Item number
For 39 notification item. Today, my lord, 28 days, and after the police remand, my lord, as per the prayer of the police, I was sent to the judicial custody. And forwarding for disclosure, that I have cooperated with the police, my lord. For the forwarding report, my lord, I have cooperated with the police and I have disclosed and my custodial detention is not necessary as per the police forwarding report, my lord.
Whether perusal of case diary
Yes,
would be necessary.
Just for
Hey.
my lord, being 29.
Mr. M. What is your name?
M.A.I. Hussain.
Mr. M.A.I. Hussain, learned counsel for the petitioner of God, Mr. P.B. Gogoi, learned additional public. Call for the case diary. Fixing 2911 for case diary.
Oblige.
item number 4.
Please, Your Honor. Application under section 439. Here I am behind the bar since 42 days now. I was sent to judicial custody on police remand on 4/10/2023. After I have surrendered myself before the Honorable JNFC Court of Lakhimpur. Kindly peruse to page number 11, that is the FIR. my lord. Here I have been implicated as accused number 3.
This is pending investigation or charge sheet.
It is still under investigation. At this stage, my lord, case diary may be
Mr.
W.R. Mehta.
W.R. Medhi, learned counsel for the petitioner of God, Mr. P.B. Gogoi, considering the fact that considering the nature of allegations leveled in the affair, perusal of the case diary would be necessary. Hence, call for the case diary. Fixing
412.
412 for the case.
Oblige. Please, Your Lordship. Lordship, as of today, 62 days behind the bar, accused has been arrested on 14/9/2023. Lordship. Lordship, allegation is under section 304B. And FIR is on page 12. Lordship.
We'll call for the case. Heard Mr. D. Medhi, learned counsel for the petitioner, also heard Mr. P.B. Gogoi, call for the case diary. Fixing
2811.
2811.
The accused has a old ailing mother who is alone right now in home. Kindly case may be fixed on next week on any day. Lordship.
Is it possible?
28 short. 14. 23rd. 23rd.
Fixing
Bolton
23rd.
Brother.
Oblige.
Wait, please. Lordship, 439 related. Today is 20 days, Lordship, behind the bar. Allegation against under section 326, Lordship. Only. Yes,
Let us call for the case diary. Heard Mr. R. Islam,
Let-
learned counsel for the petitioner of God, Mr. P.B. Gogoi, learned petitioner for the prosecutor. Call for the case diary. Fixing
412.
412
Lordship, no, can it be 28? 28 is another matter is fixed. When?
pertaining to same case.
28. Same case.
Fixing 2811 for the case diary.
Oblige.
Item number 7.
May please, your Lordship. Lordship, 439 application, my lord. 45 days as on date, my lord, behind the bar. 2 accused has been, my lord, released by the trial court. And 2 of them are before this honorable court. Allegations are, my lord, 420, my lord.
Why
and
you were not released by trial court?
Because, my lord will kindly come to page 28.
Your prayer was rejected by trial court
Yes, my lord.
after perusing the case diary.
Yes, my lord.
Let us peruse the case. Heard Mr. D.P. Sinha, learned counsel for petition. Also heard Mr. B.B. Gogoi, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
612.
612 for the case.
Right.
Item number 8.
May I please? The here are the petitioner is languishing jail my last for last my 84 days, my lord. The
84.
seizure two is attributed my lord against the petitioner, my lord. Allegation is that my lord, he killed his wife, my lord, by setting fire on her, my lord. So, can it be fixed on Monday or Tuesday, my lord? By Tuesday, my lord, the specific period to be completed, my lord. 90 days will be completed.
Third, Mr. S. Thakur, learned counsel for the petitioner. Also heard Mr. Yes, I forgot your name.
B. Sharma, my lord.
B. Sharma.
My lord.
Heard Mr. B. Sharma, learned additional public prosecutor. Considering the nature of allegations leveled against the present petitioner in the affair, the result of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary. Fixing
21, my lord.
2111 for case diary.
Item number 9.
Please, Your Lord. Lordship, in this case, accused is behind the bar for 128 days as of today, Lordship. Lordship, the matter is charge-sheeted matter. And the charges have been framed on page 17, Lordship. Order of framing
And
of charges, Lordship.
why your application has been rejected by the trial court?
Lordship, on page 18, page 19, it has been mentioned that last para, Your Lordship, accused has been have been charge-sheeted for counterfeiting fake currency note. The offense alleged to have been committed by the accused person serious in nature. There is no guarantee that they will not indulge in commission of similar offense. As such, at this stage, I am not inclined to grant bail to the accused person. As such, the prayer of bail to the accused person on consideration stands rejected, Lordship. Lordship, charges have been framed on under section 120B, 489A, 489C of IPC. Lordship, in this case, Lordship, FIR is on.
Yes, whether scan copy would be
Yes, my
necessary.
lord. Scan copy.
I'm not an FIR name accused, Lordship, and nothing has been recovered from my position, Lordship.
Oh, my lord, he is charge-sheeted and my lord. After
Heard Mr. D. Medhi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Safiqul Islam, who has been detained behind the bar since last 128 days, within brackets since 10/7/2023, in connection with Sessions case number
138.
138/2023. Stop. It also appears that by order dated 1/9/2023, learned trial court had rejected the prayer for bail of the present petitioner. Hence, perusal of the scanned copy of the case diary, scanned copy of the case record of Sessions case number 138/2023, as well as scanned copy of the case diary of STFPS case number 5/2023 would be necessary for consideration of the instant bail application. Hence, call for the same. Registry to take steps for requisitioning the aforesaid scanned copies. Fixing 15 days.
The date may be given.
Yes,
13-12.
13/12.
Obliged, sir.
For motion item number 10. My pleasure, Lordship. This transfer petition for transferring the FC criminal case number 288/2023 pending before the principal judge number 2, Lordship, Kamloops Metro. So petitioner is now working as a constable and he is posted in 13 April.
Your husband,
Yes, Lord.
father, it is 125 proceeding.
Yes, Lordship. She is staying with other men, Lordship, in Nagaon, Lordship, and their daughter also studying in Nagaon. and the petitioner original residence is Nagaon. So lordship, the respondent only to harass the petitioner lordship institute this petition by putting her address as to Alkusi lordship. This is her parental house.
Let us issue notice
It is notice to the respondent number 2.
Lordship, till returnable date, this,
after service of,
so it will be difficult for him because his official duty lordship.
but this is 125 procedure.
Earlier due date also he could not appear to.
You need not to appear. You may engage a counsel till this, till returnable date. You need not
Earlier
to
due date also he taken time for filing WS lordship. So till returnable date lordship is.
No, in 125 proceeding, your presence is not required. You need not to go there. You engage a counsel and file your WS till we hear the other side. Our Miss
Peace order.
P. Soharia, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 407 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Krishna Bahadur Thapa, praying for transferring the case number FC within bracket criminal 288/2023 under section 125 CRPC, which is pending before the court of learned principal judge, family court 2, Kamrup 2, Kamrup Metro Guwahati, to any court of competent jurisdiction at Nagaon. Issue notice to the respondent. Oh, you are not required.
Yes, respondent number 2, my.
No, you are not made a respondent. This is
Only
a-
one record.
You are not required.
My.
B. Sharma Tupati. Issue notice to the respondent. The petitioner shall take steps for issuance of notice on the respondent by registered post with ID within 3 days from the date of this order, returnable after 3 weeks.
Short date maybe.
You want a fixed date?
Yes.
After 11th.
Item number 11, public.
Instead of after 3 weeks, returnable on 11th.
Here in this case, my lord, by the impugn order, the opportunity of the defense witness was closed, my lord. And on certain ground, with the impugn order, my lord will find it just 36, my lord. 36 is the type copy, 28/23. And my lord, the petition, my lord will find it just 28.
This is a CR case,
Yes, CR, arising out of
whether
NIA.
notices have been issued.
No, my lord, this has come for the first time for the motion, my lord. So what has happened in this case, my lord, it is true that on certain occasions, the accused could not sought adjournments, and on that ground, it has been closed. But on the relevant date on 28th for my lord will find the petition is page 28. He could not come. He was the resident of a
At
page
page
28 is the petition, my lord, which was rejected. Page 28. Page 20. Exactly. 28/4. He missed his bus. He is the resident of in the district of the Nalwadi. He could not come down to Guwahati during the 4 hours. He could not have reached by another bus also. So on that ground, the petition was filed. And
where is the rejection order?
page 36, my lord, the type of it, page 36. Like that, fine.
You sought several adjournments.
Yes, ma'am, that is true. That is it reflects. I will come to that, my lord. It is not that only because of the accused the case was prolonged. I will show from the report, my lord, that on several occasions the complainant has led 3 witnesses and
My lord will kindly see page 32. E post case diary. Page 32, my lord. Page 32, my lord. Since 22/10/18, it was fixed for evidence of the complainant. From 22/10/18 till 6/7/21, 15 opportunities were taken by the complainant herself to lead the evidence of PW2 and I am not
So
on that.
you also want.
No, madam, not on that. That is my earlier petitions were considered on their own merits. On 28/4, I could not come down, my lord. I missed the bus. There was some technical stuff in the bus, and the next bus was available at around 4:12. So during the court hour, he could not have reached. So now my lord will see the another
But
aspect.
this is an order of April.
Yes, my lord.
What
April.
happened after that?
Yes, well, thereafter, you kindly see page 34, my lord. Page 34. Although the I order dated 28/4, it reflects that the matter was fixed for argument. But on the case diary, my lord, it will see that on 2/6, the next date, it was fixed for defense witness. It was fixed for defense witness on date,
Where are you reading at
page
page
34, my lord. Page 34.
34?
Page 34, just from the bottom, your lords kindly see fourth column. Fifth column is the order dated 28/4. And next date was again fixed for defense witness. I was in the impression that it matter is fixed for defense witness. Because since the orders are passed late in the evening, so we have not gone to the physical case record relying upon this. I was present on 2/6, my lord. I was present on 2/6. Your lordship will kindly see from page 37. 2/6 order is also there. And on 2/6, what has happened, my lord? The complainant and complainant's counsel were absent. They filed a petition that
But it is wrongly shown in the CIS.
yes, my lord. As per physical order sheet, it is fixed for argument. But we were relying upon this. And as such, I also made a petition on the subsequent date. On 22, on 2/6, I was present, my lord. As page 44, my lord will see that the complainant made a petition that her engaged counsel is unable to take participation in the proceeding. Page 44, my lord.
Some cost was also imposed on you.
Yes, my lord.
How
Cost
much?
is also imposed, and I am ready, my lord, as lord, your lordship is aware that to dispel reverse burden under the NI Act, I have to lead the evidence, and I have some money receipts and all which I have wants to exhibit, and the complainant will not be prejudiced, my lord. They will get the opportunity of cross-examination in the next opportunity, and if one opportunity is provided, I will appear and lead my evidence, my lord.
How much cost is pending?
Around 3,000 on 3 occasions is adjournments on 1,000 each on 3 occasions to my information. Already 3,000, and he is a retired personnel of the police department doing a pension amount of 22,000.
What is the next date fixed?
Next fixed by lot something sometime in the month of January, maybe. First week of January. Exact date is not with me, but it's in the month of January. So on the next date, my lord, I will appear without seeking any further adjournment. I will lead the evidence and it's be considered.
Third, Mr. G. Yara, learned counsel for the petition. This application under section 482 of the Code of Criminal Procedure, 1973 has been filed. No, next date is January.
Yes, my lord.
Let us give an opportunity to the
Because another means to obtain the order of the High Court, Novel High Court, and that is why under before the lower court, my lord, under
Then
the NI Act,
if the
next
next
dates are
date,
fixed after 3 months, 4 months only.
then we are issuing notice to the this one. We are not, I was intending to dispose it off, but let us hear the
Okay, consider.
respondent. has been filed by the petitioner for quashing of the order dated 28/4/2023 and subsequent orders passed. You are praying for quashing of all subsequent orders
Yes, but because as per the physical order sheet, it is
passed by learned judicial magistrate first class number 3 thus number 3, Kamrup Metro in CR case number 1752/2018. Issue notice to the respondent. The petitioner shall take steps for issuance of notice to the respondent by registered post with AD within 3 days from today, returnable on, give a date in the December before vacation. Second week, 18, returnable on 18/12.
that is not pray for interim. We take
No interim, there is no question of interim
So
because
that
your
is
next
done.
date is fixed on.
of that.
Item number
My lord, the petitioner before Lord said, my lord, the accused in the incident FIR, my lord, Annexure A. My lord, uh, actually, my lord, the love affair was, my lord, taken place between the petitioner and accused number one.
Have you filed the
Yes,
additional
I have
affidavit?
filed, my lord. On earlier occasion, my lord, on the very date, my lord, I filed, my lord, by filing an affidavit, my lord, I have annexed the impugn order. Now, my lord, may I pray only 15 days time to enable them to appear to the trial court to proceed the case duly, my lord. So that is my humble prayer.
No, what has happened in this case?
My lord, happened,
No.
my lord, an FIR was lost, my lord, because there was a love affair between the accused number one and the victim.
Okay.
And victim was arrested and he is released. My lord, the petitioner number one was arrested and released on bail.
Okay.
So, but the other petitioners are concerned no way involved. However, my lord, they appeared before the trial court, my lord, and they were granted bail initially. And they are the illiterate person and they went away to Karnataka for their livelihood. They were not aware about the proceeding. In the meantime, the charge sheet, my lord, showing absconder is issued, my lord, against them, my lord. Now the apprehension of arrest is there, my lord. So we are not in a position to appear before the tribunal. My lord, we have no negligence, my lord. My lord, we will appear every date, my lord, before the trial court to proceed the case, my lord. My lord,
No,
only
here in this 482 petition,
my lord.
you are before this court for praying for setting aside order dated 23/3.
My lord.
Which is that order? At
My lord,
page-
Lordship, may kindly see the affidavit, my lord, additional affidavit, my lord. I have filed. Lord, inadvertently, my lord, a mistake was taken place, my lord, by not annexing the I'm sorry
By
for that.
standing warrant of arrest.
My lord,
Next date is not fixed.
not treatment,
Okay.
my lord. Within 15 days, my lord, I will, we, all of them, my lord, will appear.
Mr. A. Ali. Let them appear. Mr. A. Ali, and counsel for the petitioner. Also heard Mr. P. Sharma, and the additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Muhammad Muntaj Ali, number 2, Muhammad Hazrat Ali, number 3, Muhammad Khudeja Khatun, alias Muhammad Kalia Ma, and Muhammad Salemon Beva, impugning the order dated 23/3/2023, passed by learned. Passed by
Order to
Was by SDJM S. Dorong Mongolwai.
learned SDJM S. Dorong Mongolde in GR case number 1892/2011, whereby standing warrant of arrest were issued against the above named petitioners, and the case was filed. Stop. Learned counsel for the petitioner submits that the petitioner number 1 was, all the petitioners were granted bail.
But the petitioner number one was arrested and other petitioners simply appeared and they were granted bail
By,
by the trial court.
then how they were shown as absconder in the charge?
My lord, SRCT is submitted thereafter.
No, I am not clear. Charge sheet was submitted after filing of charge sheet, whether you appeared or?
No, my lord. No. After filing the charge sheet, the petitioners were not appeared.
Okay, when you appeared?
My lord, appear earlier, initially.
When?
My lord,
What was the occasion to appear before trial court, before filing of?
my lord,
If there will be some order.
Of course, I have collected all the entire order sheet, my lord, original copies, my lord.
No, you tell me
My-
when they were granted bail. Your submission is that number 1, 2, 3, 4 were on bail.
My lord, 30/12/2011, accused Habibur Rahman was allowed to go on bail.
Flag that.
First page, my lord.
And other,
My lord,
Others are like my.
flag detail.
এইটু আপনার হবিপুর এক নম্বর
Habibur was,
হবিপুর was my lord on 30/12.
but Habibur is not before this court.
Yes, Habibur is not before this court today. হবিপুর তো আপনার বেলে কে জন
This Mumtaz, these petitioners, whether they were allowed to go on bail. Mr. Ali,
my lord, my lord.
last line.
My lord,
No, these are not the petitioners. These are Habibur, Shahidul.
my lord. My lord, another order may be changed, my lord.
একটু হয় না
No, first verify whether they are petitioners.
হয় না সাইল
Or you take time, go, you
My lord,
give
Lord,
answer.
my lord, their names are there.
Then why have you given this order?
My lord, actually, I'm sorry, I was not prepared earlier. Related persons. My lord.
Okay. Thereafter you defaulted.
Thereafter, diplomat.
Learned counsel for the petitioner has submitted that all the above named petitioners were granted bail by learned trial court by order dated 21/2/2017. However, as the accused persons are illiterate persons and they went to where you went?
Karnataka.
They went to Karnataka for their livelihood. They defaulted in appearing before the learned trial court. And accordingly, learned trial court issued standing bailable warrant and standing non-bailable warrant against all the petitioners by the order dated 23/3/23, which is impugned in this case. Learned counsel for the petitioner has submitted that the petitioners are ready to face the trial and they shall appear before the court, learned trial court, and will cooperate in the trial. However, they are seeking protection so that they may appear before the learned trial court as there is a standing non-bailable warrant of arrest issued pending against them. Learned, considering the submissions learned additional public prosecutor does not opposes the prayer of the learned counsel for the petitioner seeking interim protection so as to facilitate them to appear before learned trial court. Stop. Considering the submissions made by learned counsel for the petitioner, this criminal petition is thereby disposed of with an observation, with a direction that the petitioner shall appear, that the above named petitioner shall appear before the learned trial court within 15 days from the date of this order, and to facilitate their appearance before the learned trial court, the pending non-bailable warrant of arrest issued against them shall be kept in abeyance for next 15 days.
They may be allowed to, since they are at previous date.
No, that prayer you have to, after appearing before
Maybe taken into
learned trial
custody.
court, the petitioner may pray for regular bail before the learned trial court. We are giving you protection so that you appear. Your non-bailable warrant of arrest is kept in abeyance. You appear before trial court and make prayer before that trial court for bail.
May pray on our appearance, my lord. Maybe bail may be considered to get there.
No, you file an application first.
Yeah.
With above
No.
observation, this criminal petition is thereby disposed of.
Item number 13.
Outliners. May it please lordship. So this is quashing of FIR lordship. The petitioner lordship is a licensed timber shop holder lordship. And on forester lordship, FR1 lordship, forest department lordship, he lost an FIR against him lordship. That is under silence here lordship. FIR is 30 lordship, 30 lordship is the FIR lordship. As per lordship, the matters have collector lordship and next here lordship. The FIR at all not maintainable in this case lordship. And as per the forest regulation lordship.
Why it is not maintained?
The metal is not their lordship because no forest offense is committed here lordship. The FIR may be seen lordship, first lordship. The FIR says lordship, as per their secret information lordship, they searched my shop lordship and found 2-3 timber logs lordship. And thereafter lordship, I was also brought to their office lordship and my seizure machine lordship. So just hijacking machine is called lordship. There is the part of my timber shop lordship. There is also seized lordship. And also I have mistake on R lordship. Had boat is become lordship. Actually, it should be brought lordship. On R, I'll make it lordship. I begin it is a port. It should be brought lordship. I was brought to the office lordship. Then R, I will put lordship. So this is lordship here. I have silenced lordship.
What is the allegation?
Yes, Lordship, I am reading, Lordship, then. That today what 3/8/2023 night at about 7 o'clock. Actually, it is not
At
7
page, at page,
or page 30, Lordship, 30. The
Yes.
translated copy, Lordship. Lordship, I am again reading today on 3/8/2023 at about 7 o'clock.
where are you reading?
Translated copy, Lordship, page 33, Lordship.
Page,
30, Lordship. 30.
but there is no today in page 30.
Item 13 is not there, Lordship. Is it item
Page,
13?
page 30, page 30 you are reading.
Yes, Lordship.
Read it again.
Yes, Lordship. The humble application is that today on Lordship got it part.
Yes.
Yes, Lordship. Today on 3/8/2023 at night about 7:30 o'clock, on the basis of a secret information, a secret operation was conducted and log of peak tree, sawn timber and timber sawn machine, it is a volumes considered, were seized with the help of assistant of the colleague and arrested the below mentioned accused person and brought, actually it should be brought, Lordship, I have written mistake, brought to him to the office of the Nagarbara Forest Guard and interrogated him. At the time of interrogation, the said person admitted his guilt, Lordship. This is the allegation, Lordship, 2-3 timbers, Lordship, that was brought, they found in my shop, Lordship, my machine.
Who is appearing for the respondent state?
It's one number 2, my lord, forest, my lord.
It's hard copy, Lordship.
There is standing counsel in the,
Yes, my lord. My
have you
lord,
served notice?
Yes, Lordship.
yes, notice me, sir.
Sharp, yeah, sharp, Lordship. The notice is there, Lordship.
My lord, I am the special public prosecutor for my lord
You are appearing.
wildlife. Yes, like I can appear, my lord, and I have to take instruction, my lord, whether this, my lord, he has any authority to sell the timber on, my lord. That machine was also, my lord, seized from his shop, my lord. Whether any, my lord,
Instruction
authority.
will take, Lordship, but
Yeah, my lord.
now, Lordship, the timber, Lordship, he has found in my shop, Lordship. There is I have mentioned, Lordship, the who brought this timber, Lordship. This is not a forest timber, Lordship. This is a timber of a patta land, Lordship, and there is my own villager's class, Lordship. I have, Lordship, kindly have page 27, Lordship. Kindly may read, Lordship. I am reading, Lordship, page 23. This is the person, he is the villager, Lordship. He brought this timber, Lordship, to my machine, Lordship. Because that timber, Lordship, the big tree, Lordship, it was, Lordship, situated on his own land, Lordship, patta land, Lordship. I have given the patta Jomandi copy, Lordship. Jomandi copy may seen, Lordship, page, I am coming one by one, Lordship, page 24. From the on this patta land, Lordship, this tree was situated, Lordship. And the tree is photo, Lordship, cutting photo, Lordship, that is page 26. There is the stump of the tree, Lordship, page 26, is in, Lordship, the bottom, Lordship. The cutting trees remaining part is here, Lordship. And there in upon upside, Lordship, there is electricity wire is there, Lordship. So, Lordship, that tree, Lordship, was connected to the electricity wire, Lordship. That's why their villager, Lordship.
Now, what is the state after lodging of the FIR investigation?
Lordship, I want, Lordship, as the FIR, Lordship, it is not, Lordship, the matters does not say, Lordship, this is the FIR is a lie, Lordship. So, Lordship, it may be state, Lordship. Because the person who brought this.
No, what is the urgency for this staying?
Lordship, my machine is seized, Lordship. Now, without, on the basis of this FIR, Lordship, the false FIR, Lordship, my machine was seized. My shop also was seized, Lordship, in fact. So, Lordship, on the basis of this illegal FIR, Lordship, my whole liabilities they have taken away, Lordship. Even I filed representation, Lordship, they are denied.
My lord, the timbers on machine, my lord, they also require permission, my lord, from my lord.
No, it is a part of the
So,
shop,
my
Lordship.
lord, that, my lord, I have to inquire, my lord, whether that is illegally, my lord, install or, my lord, there is some.
Let him seek instruction. We are giving a short date.
Yes, Lordship, there is short date, Lordship.
Heard,
And
Mr.
it will be considered on the day, Lordship, because matters, Lordship, the forest regular says, Lordship, where the offense is related to forest produce, Lordship, any forest produce, Lordship, then also the forest.
This is item number
13, Lordship,
13,
13.
1-3.
1-2.
Okay. Heard Mr. S. Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure, 1973, read with Article 227 of the Constitution of India, has been filed by the petitioner Saiful Islam, CHAI, Saiful Islam, praying for quashing the FIR dated 4/8/2023, 4/8/2023, lodged by opposite party number 3. On the basis of this FIR, whether any case has been registered?
No, Lordship. I have not found any record in the case. Okay, yes, number is there, Lordship,
Yes.
but the number is not here, Lordship. In the next page, Lordship, the number is there, Lordship. Kindly may have page 32, Lordship.
Yes, 32.
Yes, Lordship.
Page number 30.
32.
Last page. Madam.
Subject intimation, Lordship, there is the section of there, Lordship.
Where is the case number?
Lordship is subject intimation under section 7, Lordship.
My lord, the very first line, my lord, that is OR, my lord, that is offense report, my lord. That is it.
Or
Yes, my lord, that is.
it is not legible.
It is not legible, my lord. It is signified.
Or Lordship may take page, another page, Lordship, may be seen from seizure list, Lordship, page 29, here also, Lordship,
Yes.
Lordship, page 29, Lordship. Under section 34, 35, Lordship, in the above one line, Lordship.
Yeah, it is legible.
Section, Lordship, about last line, Lordship, there was 34, 35, 40, 41.
No,
Okay.
which case, if suppose we want to call for the case record?
Well,
Which-
Lordship, this is the Lordship offense, the memo number, what my friend says, Lordship, that is the offense, Lordship. Memo number, let's say the first page, page 31, Lordship, that is the offense report, Lordship. Memo number NBR 3 offense 107. This is the number, Lordship, perhaps in the office, Lordship. Page 33, first line, Lordship, memo number. Page 32, Lordship, memo number, Lordship.
Read out.
Yes,
I am
memo number, Lordship, memo number dot and capital NBR /03 slash offense /108.
It is 107.
Yes, 107, Lordship. 07 last.
What the? Only quashing the FIR dated 9/4. Issue notice to the respondents and call for the scanned copy of case record of case number OR number NBR /
It is 03, Lordship, 03.
03/offense/21.
29. 29.
29. Learned additional public prosecutor submits that he needs some time. No. As Mr. P. Sharma, learned additional public prosecutor appears for all the respondents, no formal notices need to be issued to the respondent. However, learned additional public prosecutor submits that he needs some time for seeking necessary instructions in connection with the petition filed by the present petitioner. The prayer is allowed. Let this case be listed again on
On my lord, 23rd 11.
23rd 11. in admission court. The prayer for interim relief shall be considered on the next day.
Wait, my lord.
Item number 14.
Wait, please, your lordship. 438 verification. FIR space 10. Mary. After submission, that the accused number has been committed upon my daughter named Elizabeth, 19 years, by making false promise to marry her in last 3 months. At present, the accused number 2 and 3.
We are calling for the
Yes, sir.
case.
In the meantime, I have information that the matter has been transmitted.
Oh,
Then you appear before the trial court.
Charge number lordship 163.
Heard Mr. S. Ali, learned counsel. MZ Shah, learned counsel for the petitioner, who submits that though the petitioner has filed in the instant petition under instant application under section 438 of the Code of Criminal Procedure, 1973, apprehending his arrest in connection with Jogi Gopa PS case number 131/2023. However, he has instructions that in the meanwhile, the charge sheet has already been laid, bearing charge sheet number
163.
163
2023.
/2023,
Dated
and
36 2023.
dated 36 2023. And in view of the same, he prays for, you want to withdraw this?
Maybe director have to appear before the trial.
The want to approach the learned trial court for seeking relief before the learned trial court. In view of the submissions made by learned counsel for the petition, this anticipatory bail application is disposed of with an observation that the petitioner may approach learned trial court and may seek necessary relief before learned trial court, if so advised.
Item number 15.
Lordship, in this case, I am not on record, Lordship. I am appearing on this Mr. 822. I'm not. This is the application, Lordship, under for 38, Lordship. Lordship, will find out after at page 10, Lordship. But Lordship, 9. That is the vernacular, Lordship. Page 9, Lordship.
Yes.
Where is it, Lordship?
Yes.
Mohan Hanmanpur, Binit Nivedon is joining us the attached not.
Whether case diary would be required.
my lord.
Lordship, there is a love affairs between the alleged victim and the present petitioner, Lord. Say, along with the petitioner on 28, that is the first day, Lord. And thereafter on 29, on the request of the parents of the present petitioner, she go back to her home, Lordship. She again eloped, Lordship. That is on the 210, Lord.
Considering her age, my lord,
What is her age?
It's 17 years, 4 months, Lord. And the petitioner is 19 years old, Lordship. Actually, there is a love affair, Lord.
Petitioner is 19 years.
19, Lord. What about a minor, Lord?
Show me where is the love affair.
Lordship, the annexure B, Lordship, that is page 10, Lordship. The what come
Annexure?
the exchange
Annexure?
annexure B, page 10, Lordship. At the very first line, Lordship, it's Diksha Borwa, that is the victim, Lordship.
Okay. Let him appear before the trial court,
Lordship, I'm ready to.
before the investigating
Lordship.
officer. In the meanwhile, we are calling for the case.
Lordship.
Mr.
I'm BK Gogoi, Lordship, appearing on the X1.
Mr.
BK Gogoi.
B.K. Gogoi, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Abhinash Bharali who is aged about 19 years and who is apprehending his arrest in connection with Dhokwa Thana PS case number 118/2023 under section 366 of the Indian Penal Code. The gist of accusation in this case is that on 2/10/2023, the one Shri Patik Borua had lodged an FIR before the officer in charge of Dhokwa Thana Police Station, inter alia, alleging that on 28/9/2023, the daughter of the first informant eloped with the accused named in the FIR, that is the present petitioner. And thereafter on 29, she voluntarily appeared before the police. And after her medical examination, she was given in the custody of the first informant. However, it is alleged in the FIR that on 2/10/2023, the daughter of the first informant again eloped with the accused person. Now, where is
No, she is in the house of the present petitioner.
present petitioner?
Lord.
But she is a minor girl.
He is a minor girl.
Lord. That is true, Lord.
Then you send her back to her parents' house.
Now she refused to go back to her home, Lord. And there is no any attempt from the parents of the petitioner. That is the application.
Then you appear before the IO along with the victim.
Lord. That can be.
Okay.
My lord, kindly later 164 statement be recorded, my lord, before honorable magistrate, my lord.
No, but police has not yet recovered her. She is with the victim.
Yes, my lord.
With
I'm ready to produce the
Okay.
victim also.
I have to produce.
Learned counsel for the petitioner has submitted that the petitioner is having love affair with the daughter of the informant, and it is the victim girl herself who had eloped with the present petitioner. In support of his submission, the petitioner has furnished these are the photocopies of the screenshots of some WhatsApp messages exchanged between the victim girl and the present petitioner. So on the other hand, learned counsel for the learned counsel for the petitioner has also submitted that the victim girl is presently staying with the petitioner and she has refused to go back to her parents' house. And her parents have also not tried to take her back to their house. Stop. On the other hand, learned additional public prosecutor has submitted that considering the nature of offense involved in this case, perusal of the case diary would be necessary. And it is also submitted that in the meanwhile, the statement of victim may have to be recorded under section 164 of the Code of Criminal Procedure, considering the submissions of learned counsel for both the side, let the case diary be called for fixing.
Fixing, my lord. 7/12, my lord.
Fixing 7/12 for case diary. However, in the meanwhile, as it appears from record that the petitioner and victim are having love affair, the petitioner is hereby directed to appear before the investigating officer of Dhokwa Thana PS case number 118/2023 and cooperate in investigation. Will you be able to take victim with you?
Yes, yes.
he shall also take the victim girl along with him to the police station. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Dhokawkhana PS case number 118/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, subject to the condition that he shall cooperate with the investigation. In the investigation. Number 2, he shall not directly or indirectly make any inducement, threat, or promise to the victim girl or to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such facts before the investigating officer. Let this case be fixed again on 7th of December 2020.
Deeply obliged, Lord.
Item number 60.
May I please go ahead, sir. Petition under section 438 of the RBC Lordship FIR at page number 9, Lordship, type to be vernacular copy, page number 13, Lordship. Charge sheeted measure, Lordship, petitioner also approves the court.
It is a charge sheeted
Charge
case.
Yes, my lord.
approves the court below, Lordship. Learned court below rejected his arrest bail, Lordship. Accordingly, he is before the honorable court.
It is a charge sheeted matter
Charge sheeted,
Yes,
Lordship.
and
Thereafter, he approves the court below, Lordship.
And
Order
that was also rejected, my lord.
rejected, Lordship.
you
And-
approach the trial court.
Yes.
Trial court or sessions court,
Session court,
praying for
arrest bail, Lordship, in connection
you,
with the
you have, and the committal court has issued summons to you.
summons to him for appear, Lordship. Next date on 2nd January.
So why are you not appearing before committal court?
Lordship, kindly see FIR, Lordship, section 376 is
Okay.
there, Lordship. And in the charge sheet, he also shown as a absconder, Lordship. If he is appeared, he will be arrested. Lordship. Kindly see FIR page number 9, Lordship. Vernacular copy page 13, Lordship. Informant is about 19 years, Lordship. He is 21 years. Lordship.
Now, physical relationship with the victim was
On promise of marriage, Lordship, but it is totally false, Lordship. Thereafter, she got married, Lordship. After losing the FIR along with another person, she got married, Lordship. Now she is a married, Lordship. I have also stated in the there are 6, Lordship. There are 5, Lordship. But this petition, Lordship, she got married with another person in the area, Lordship. After losing, now she is married, Lordship.
My lord, kindly see page number 21, my lord. The last para, my lord.
yes.
Last para, my lord. That on perusal of the same, my lord, it is found that the charge sheet has been submitted against the accused person under section such and such.
Yes.
And my lord, also there are intimidating materials against the accused person. So
Maybe,
considering all this, my lord, that was bail was rejected.
in the FIR herself stated that, Lordship.
My lord, FR, then my
She
lord
said-
charge sheet filed and then he is charge sheeted, my lord.
She has given
So my lord,
consent, Lordship.
kindly, my lord,
Many
all
judgment.
for a scan copy of the record, my lord,
Maybe-
and my lord, at least, my lord, the victim statement, the victim should be examined, my lord.
Yes,
No, victim
She had-
statement under section 164 would be there. His
Yes,
case
yes.
is that it is a charge sheeted case
Charge
my-
sheet, Lordship.
and he will
will
face
appear.
trial.
Yes.
He will face trial, Lordship, each and every day he will appear, Lordship. And FIR itself, Lordship, everything is clear. He herself given consent, and in this regard, various judgment of the theory, Lordship is aware about the judgment, Lordship, whether in this case 376 is extracted or not, Lordship.
No, we are not into that aspect.
Yes, Lordship.
We are,
According to
Now-
Lordship,
when the trial court has issued summons to you,
Summons, Lordship, on
Then why are you not appearing? That is the question.
I will appear, Lordship. Now I am appear, Lordship. Is under 376, Lordship. He will be arrested. He will send to the custody, Lordship. Someone was issued on, Lordship. Next date, Lordship, fixed on 2nd January 2024 for execution of summon, Lordship. Simply summon was issued to him to appear before the trial.
What is the next date?
2nd January 2024. 2/1/2024. He will appear, Lordship. He will face the trial, Lordship. That he may be allowed to go on bail in the
Heard Mr.
ABT.
ABT Hawk, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973 has been filed by the petitioner Hussain Ahmed, who is apprehending his arrest in connection with. What is the GR case number?
Their case number, Lordship, 1800/2022.
Where have you mentioned it?
Here, Lordship, I have one photocopy of the summon, Lordship.
No, here you have not mentioned in your.
I have received later. Lordship.
Then let us call for the.
He will appear, Lordship. He may, in the FIR, everything is clear, Lordship. With the consent, there is no rape, Lordship. Nothing is there, only cheating may be there, Lordship. Fall on false.
GR case number. Why have you not mentioned GR case number in?
I have received on later on, Lordship. I will file an additional affidavit to bring on record the summon, Lordship. In the meantime, Lordship, he may be called for, he may be allowed to go on bail, Lordship. Now he is absconding, Lordship.
No, where is the apprehension of it?
When you will appear before the trial court, Lordship.
438 lies only when there is an apprehension of it.
Yes.
What is your apprehension?
Non-bailable sections are there, Lordship.
But summons have been issued.
Summons have been.
Summons issued, Lordship.
So you explain to me how you are apprehending on the next day. Why anticipatory bail should be granted to you?
If you will appear, Lordship, in the trial court, maybe, Lordship, will send to the judicial.
Why? Why?
Non-bailable section is there, Lordship.
If non-bailable section is there, then why the trial court will send you to jail?
Accordingly, Lordship, he has approved the session court, Lordship. This case is further triable by.
No, I am not understanding. Summons have been issued. 438 lies if apprehension of arrest is there. You have to explain it to me how that apprehension comes to you. Why you are apprehending that you will not be allowed to go on
In the
bail?
charge sheet, Lordship, they have mentioned, prosecution mentioned as a absconder, Lordship. Next date, fixed on, Lordship, 2/1/2024.
Charge sheet?
Meantime, he will be arrested,
No,
Lordship, for
you are not
executing
answering
summons.
my question. My question is, the committal court has issued summons to you. Then what is the cause of apprehension? When you answer my query on the next date.
Non-bailable section is there, Lordship. If he appeared before the trial court on the next date, Lordship, that may not be allowed to go on bail.
Why? Where is the bar that
Bar is not there, Lordship, that may not be
that
allowed,
trial court may not grant you bail?
may not be granted.
Why? No, on what is the basis of that apprehension that trial court may not grant bail? You come prepared with the answer. What was the answer?
And the court will also reject it, the pre-arrest bail.
In connection with GR case number
1800/2020.
1800/23 pending before the court of which court?
Chief Judicial Magistrate, Karimganj.
Pending before the court of learned Chief Judicial Magistrate Karimganj. Stop. Learned counsel has also submitted, learned counsel for the petitioner has also submitted that the learned court of learned chief judicial magistrate has issued summons to the present petitioner on being queried as to what is the cause of his apprehension of the petitioner of being arrested when the committal court has issued summons to the petitioner. The learned counsel for the petitioner had sought for some time for answering the said query. The prayer is allowed. In the meanwhile, let the scanned copy of the case diary of the Ratapari PS case number 278/2022 be called for from the Court of Learned Chief Judicial Magistrate, Karimganj. Let this case be fixed again on. Give 20 days stay. 16th. On that day, you answer the query.
18th.
18th.
Item number 17.
Yes.
May I please lord. Let's note 438 application, my lord. The FIR case 8, my lord. Is a, my lord, counter case against our FIR on, my lord, 1st of October, my lord. Is 8.
Page 8 is the FIR.
Dear FIR, my lord.
FIR against you.
Lord.
Okay.
There's two occurrence here, my lord. One took place on 1/10/2023 at about
But the
11.
allegation is that you have stabbed. What is your name?
Manik, my lord. Manik Teta.
That you have stabbed the victim with a knife,
Yes.
causing grievous injuries on his
This is
person.
a subsequent occurrence.
But this is a grave allegation.
Lord. And to that effect, my lord, the allegation is absolutely false, my lord. He was not sustained any such injury.
Let us call
Lord.
for the case there.
And on 1st of October, my lord, he is a habitual drunkard, my lord. When I was going home, my lord, after my lord closing shop, he engaged my lord in quarrel on 1st of October. Then we filed FIR. Again, my lord, on 2nd day, my lord, he again attacked. And thereafter, my lord, the counter case has been filed. So I will cooperate with the investigation if anything found against
No,
me, my
but
lord.
considering the allegation without perusing the case there. Yes, Mr. Sharp.
Yes, my lord. Finally, fix on my lord 612.
Heard Mr. R. Ali, learned counsel for the petitioner, also heard Mr. P. Sharp, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary is felt necessary for consideration of the instant anticipatory bail application, hence call for the case diary, fixing 16/12 for the case diary.
Fraud date, my lord, as your lordship is not considering interim, my lord.
612, my lord.
6/12, sorry, 6/12.
Item number 18.
Yet, 438 value. The hard pace 10.
Who is before this court?
What if
Yes,
what if Noor Amin and
Zaidul,
Jiyadul?
Jiyadul.
Lordship already poetry is enlarged on bail by this honorable court. Lordship kindly have a look at page 19. Page Lordship 17. It is, Azahar lost purely on suspicion, Lordship. Lordship, and if we look at earlier order, one of the copies was enlarged on bail by this honorable.
You are named or not?
Yes,
You
name,
are named accused.
Lordship, he is also named,
He is also named.
named.
On
Lordship,
what ground he was arrested?
Lordship, may I read, Lordship? Page 17, Lordship. Upon perusal of the case diary and the postmortem report, it is seen that as per the medical opinion, the cause of death of the disease is due to asphyxia, due to drowning. There is no material available in the case diary at this stage of investigation to suggest that the petitioner was involved in commission of the offense alleged in the FIR. Further, in the postmortem report, there is no medical opinion which reveals that the deceased was subject to any injury or torture which had led to his death.
Yes, Mr. Chair.
Yes, my lord, that is the finding. my lord.
Let him appear.
My lord.
Where the closing of this. Heard Mr. L.R. Majumdar, learned counsel for the petitioners. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Ziadul Mia and Noor Amin, who are apprehending their arrest in connection with Mankasar PS case number 26/2023 under section 120B/365/302/201 of the Indian Penal Code. The gist of accusation in this case is that on 21/2023, one Amirul Islam lodged an FIR before the officer in charge of Mankasar police station, inter alia, alleging that his brother, namely Noor Nobi, went missing on 19/10/2022 while he was returning to his house from the house of his father-in-law. It is further alleged in the FIR that on 21/2023, one dead body was recovered lying in an abandoned ditch at village Kakripara in Beparipara, and upon noticing the structure and wearing apparels, it was assumed that it could be the dead body of the informant's missing brother. It is further alleged in the FIR that on 19/10/2022 at night, a public commotion took place and his brother was seen with other persons, and since seen with the accused named in the FIR, including the accused persons named in the FIR, including the present petitioner, and it is suspected in the FIR that the said accused persons had kidnapped the brother of the first informant and murdered and committed and killed him after subjecting him to torture. So, learned counsel for the petitioner has submitted that though the petitioner has been named in the FIR, however, he is in no way involved in the offense alleged in the FIR. It is further submitted by learned counsel for the petitioner that one of the co-accused who was also named in the FIR, namely Zorul alias Johirul Islam, has already been granted bail by a coordinate bench of this court after perusal of the case diary. While granting bail to the after perusal of the case diary as well as post-mortem examination report. Stop. While granting bail to the co-accused, it was observed by the coordinate bench of this court that on perusal of the post-mortem examination report, it reveals that there is no medical opinion that the deceased was subjected to torture or had any injury. And according to medical opinion, the cause of the death of the deceased was due to asphyxia, due to drowning. Stop. Learned counsel for the petitioner submits that the present petitioners are ready to cooperate in the investigation. And as the one of the co-accused has already been granted bail, and they are similarly situated with that of the said co-accused, they may also be allowed to go on bail. I have also heard, considering the submissions made by learned counsel for the petitioner. Mr. Sharma, you are opposing? No.
No, my lord,
let him-
as parity, my lord.
Learned additional public prosecutor fairly submits that the petitioner seems to be entitled to protection of under section 438 on the ground of parity, as one of the co-accused has already been granted bail by a coordinate bench of this court. In view of submissions made by learned counsel for both the sides, the petitioners, namely Ziadul Mia and Noor Amin, are hereby directed to appear before the investigating officer of Mankasar PS case number 26/23 within a period of 10 days from the date of this order and cooperate in investigation. Stop. If they do so within the stipulated period of time, in the event of their arrest in connection with Mankasar PS case number 26/23, they shall be allowed to go on bail of rupees 30,000 with one surety of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following condition: that they shall cooperate in the investigation. Number 2, that they shall not directly or indirectly make any inducement, threat or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to the investigating officer. Number 3, that the petitioner shall not leave the jurisdiction of Mankasar police station during the pendency of the investigation without prior leave of the investigating officer. With above observation, this anticipatory bail application is hereby disposed of.
Oh, like,
Item number 19.
May I please your lordship? Incident cases of 438 under CRPC, my lord. Kindly see the affair in page number 12. my lord.
Yes,
Yes, my lord, in the third paragraph, I am I am not the FIR named accused, my lord, but my Alto car has been seized by the police officer. And for this very reason, I am approaching this honorable court for the pre-arrest bail. My lord, in the FIR, it is mentioned that further in the third paragraph, my lord, further in the course of interrogation, the accused driver of the fuel tanker stated that the oil tanker was loaded at the Bongaigaon refinery, Oil Corporation Limited, and to be uploaded at Tezpur. It is also found that the owner of the said Alto car, namely Tapan Nath, is the purchaser of the said oil theft, who has escaped from the PO place of occurrence. Moreover, the fuel salan also indicates that the fuel was loaded on 7/27, 10/23
what
at
is your
Bongaigaon
name?
and is to be loaded at Tezpur.
What is your name, Tapanna?
My lord, I am Tapan Nath. My lord, I am no way involved in this particular case, my lord. On that very day, that is on 28/10/2023, when the FIR was lodged by the SI of the concerned police station. Before that, the arrested person, the person who was accused and was arrested, that is Samsulok, who took my car on the previous day by mentioning that he will use it for the personal reason, and I handed over the car to him, and he used it some other purpose that was not into my knowledge, my lord. So I was not anyway involved in this particular case, my lord. And apart from this, my lord, I am a reputed businessman of this particular locality, and I am also apprehending the arrest. And for this very reason, interim may be granted, my lord.
You want only interim? You don't want?
Absolute might also be given. That is after perusal of the case. Then.
What is your subject?
My lord, his involvement is in the very much in the FIR, my lord. So kindly call for the case study, my lord, at this stage, my lord. Because he is the purchaser of that, my lord, that said all oil theft, my lord. Say
The allegation is of oil theft.
oil theft, my lord. That is clearly mentioned in the FIR, my lord.
When can you, how much oil?
50 liter.
50 liter, my lord. In the previous paragraph, it is mentioned.
50 liters.
Yes.
Yes.
Let him appear.
My lord.
In the meanwhile. Mr.
M. Deka.
M. Deka, learned counsel for the petitioner. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Shri Tapan Nath, who is apprehending his arrest in connection with Sipajhar Police Station case number 338/2023 under section 379/413/34 of the Indian Penal Code. The accusation in this case is that on 28/10/2023, Shri Ranjan Tamuli lodged an FIR before the officer in charge of Sipajhar Police Station, inter alia, alleging that on 28/10/2023 at about 1:40 a.m. during a search operation which was conducted by police in the premises of one Muhammad Samsul at Dumnisoki near National Highway number 15. The police team noticed one oil tanker was parked outside the premises of the accused persons named in the FIR, namely Samsul Haq, Naval Kishore, and Kiran Yadav. During search operation, 3 numbers of fuel gallons of 50 liters each capacity was also seized, and some empty gallons of oil were also seized. And one Alto car bearing registration number AS01B Y0897 with one full loaded gallon with capacity of 50 liters, which was kept in the dicky of the said car, was also seized. It is further alleged in the FIR that during the interrogation, the FIR named accused persons have disclosed that the said Alto car belongs to one Tapan Nath, within bracket, that is the present petitioner, who used to purchase the stolen oil, stolen fuel. Stop. Learned counsel for the petitioner has submitted that he is not involved in any manner in any offense as alleged in the FIR. It is further submitted by the learned counsel for the petitioner that he has lent his car, that though he is the owner of the Alto car bearing registration number AS01BY0897, however, he has given his car to
Samsul Haq, my lord.
Samsul Haq for use, and he was not aware that his car would be used for any illegal purpose. It is also submitted by learned counsel for the petitioner that as the present petitioner has been named by the FIR named accused wrongly, the police is searching him and he is apprehending the rest. It is also submitted that the petitioner is ready to cooperate with the investigating officer. On the other hand, learned Mr. B. Sharma, learned additional public prosecutor, has submitted that the petitioner has been specifically named in the FIR, and therefore perusal of the case diary would be necessary. Hence, call for the case diary fixing.
Fixing, my lord, on 11-12, my lord.
11-12 for case diary. However, considering the fact that considering the submissions made by the learned counsel for the petitioner, as well as considering the fact that nothing was seized from the person of the present petitioner, he is hereby directed to appear before the investigating officer of Sipajhar police station case number 338/2023 and cooperate in the investigation. So if he does so, within the stipulated period of time, in the event of his arrest in connection with Sipaj RPS case number 338/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number one, he shall cooperate with the investigating officer. Number two, he shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case so as to dissuade such person from disclosing such fact to the investigating officer. Let this case be again fixed on
My lord, 11-12.
11-12 for case I.
Let's start.
Item number 20.
May I please, Your Lordship? Lordship, FIR is fed case number 12. Lordship, allegation against me, my lord, T07, T76, my lord. But FIR was not filed by the victim, my lord.
Where is the FIR?
FIR, my lord, case number 12, my lord.
The case diary would be.
Yeah.
Mr. T.K. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary would be necessary for consideration of the instant bail application. Hence, call for the case diary fixing.
29-11, my lord.
29-11 for case.
Okay.
Item number 20.
May it please, Your Lordship. Here, my lord, FIR, Your Lordship, will find at page 13. Page 13 is the FIR matter. My lord, based on my lord, secret information, my lord, NACA was conducted, my lord, and during NACA, my lord, one mini truck and one Maruti Alto vehicle, my lord, was seized, my lord, along with my lord, 60 numbers of my lord, 60 bags of permits air cannot. Page 13.
Okay.
Page 13.
60 bags of Burmese direct.
Lordship.
Okay.
Yeah, my lord, I'm nowhere connected in this case, my lord. The vehicle which was seized also, my lord, that is not of mine, my lord. But in connection with this case, my lord, subsequently, my lord, my vehicle was seized, my lord. That is another vehicle, my lord. I have annexed at page 11 and 12, my lord, the registration certificate, my lord. My vehicles are, my lord, mini truck and my lord, Eco PRO, my lord. Page 11 and 12.
No, when your vehicle seized.
Lordship, my lord, it was seized, my lord, subsequent to this case, this FIR, my lord, and I have
Why it was seized?
on the suspicion that my lord, my vehicle was, my lord, also involved in this connection in such type of process, my lord, and thereafter, my lord, I have filed Zimma application before the learned court below, my lord, page 21 and 22, kindly see, my lord, and Zimma was granted to my vehicle, page 21, kindly see, my page
Okay.
21.
Okay. No, sir. Zimma was
Granted.
thereafter.
Zimma was granted, my lord. Now, my lord, since I am the owner, we are the owner of this vehicle, my lord, I am apprehending arrest in this connection.
But in this FIR, your vehicle is not.
Seized, my lord. Though the FIR, my lord,
No mention about your vehicle is
about my
there in
vehicle,
the-
my lord, but subsequently, my lord, my vehicle was seized, my lord, and
in connection with this case.
this case, my lord. Kindly see, have a look at page 21, my lord. The present case is, my lord, Sungajan PS case number 12 of 23, my lord, corresponding to GR number 119/23, my lord. And kindly see page 21, my lord. Page 21, my lord. First paragraph, may I read, my lord?
Yes.
In the Zimma petition number 961/23 filed by the petitioner Jahangir Alam, this is the petitioner number 1, my lord. And stating that he is the registered owner of vehicle Tata 7 10 mini truck bearing registration number such and such, and Jimma petition number 962, filed by the petitioner Tohidur Rahman, stating that he is the registered owner of vehicle, Sir PRO such and such, mini truck bearing registration number such and such. And accordingly, my lord, report was called for, my lord, and thereafter page 22 kindly see, my lord. Next order, my lord, 19/9/2023, my lord. With the progress of the investigation, this court doesn't see any obstacle to deliver the vehicle to the rightful custody of petitioner who have filed petition before this court by petition number 961/23 and 962/23. By report dated 2/9/2023, the IO has stated that the vehicle bearing registration number S02DC1485 and S02DC2675 are required for further investigation. Thereafter, next breakup, your lordship may skip, my lord. Last breakup, my lord. Hence, this court deemed it prudent to hand over the aforesaid vehicle to the petitioners on execution of bond of ₹8 lakh is before IO with a direction to produce the said vehicle in the court as and when required, and that she shall not sell, alternate, dispose of, or transfer the said vehicle till disposal of this case. IO shall also prepare a pension number and shall take photographs of the vehicle before handing over those to the petitioner. The petitioner shall bear the cost of photographs. The nature of Jimma is interim at present.
Okay.
Now, because I am the
No, why are you apprehending?
because I am the owner of the said vehicle, my lord, since the case is registered under non-believable section of law, my lord. If I go to the police station, my lord, police may, my lord, take me into the custody in connection with the case.
No, why you have to go to police station?
To take Jimma of this vehicle, my lord.
It is the order of this court.
Sorry.
Order of the court. Jimma was given by the order of the honorable court. So what is this?
No, there is no.
You are not an accused in this.
No, my. Not an accused.
You may not be arrested. You go and take
Lordship,
Jimma.
Lordship, my lord, since my lord case is non-believable, my lord, there is a apprehension. That is my case.
You're... Yes, Mr. Chair.
Just, my lord, apparently, my lord, there is no apprehension. Because, my lord, the persons, my lord, mentioned in the FIR, his name is not there. And, my lord, Jimma was subsequently given to his vehicle, my lord.
There
is no apprehension.
No
This is not the case for 438.
Lordship, that may be observed, my lord, since I am not named in the accused.
Right, it is apparently the FIR.
Lordship, my lord, since case is non-believable, my lord, there is every apprehension that, my lord, I may be taken into custody. If my lord, then says so, my lord, then that may be observed, my lord. I will not be taken into custody, my lord.
I am submitting
Lordship,
from the
therefore, my
FIR.
lord, so, my lord, at this stage, my lord, some protection may be given, my lord.
Heard Mr.
K. Burwan, my lord.
K. Burwa, learned counsel for the petitioner. Petitioners also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 438 438 of the Code of Criminal Procedure, 1953, has been filed by the petitioners, namely Jahangir Alam and Shoidul Rahman, who are apprehending their arrest in connection with Sungajan Police Station case number 12/2023 under section 120B/379/411/406/413/420 of the Indian Penal Code, Indian Penal Code. Stop. The gist of accusation in this case is that on 11th of July 2023, one Sri Pawan Deuri, ASI of Police of Sungajan Police Station, lodged an FIR before the officer in charge of Sungajan Police Station, inter alia, alleging that on receipt of information through reliable sources that some illegal items are being transported from Dimapur side towards Nagaon, a Naka checking was conducted at Hologuri, Sungajang Anglong by the police staff of Sungajang Police Station. And during Naka checking operation, 2 vehicles bearing registration number AS01QC 4423 and WB16AD 0726 respectively were intercepted and were checked, and several gunny bags of Areca nuts were recovered from the side vehicle. Stop. Later on, learned counsel for the petitioner submits that though the petitioner has not been named in the FIR, neither his vehicle has been mentioned in the FIR. However, later on, in connection with the said case, his vehicle bearing registration number AS02D AS02DC 1485 and another vehicle bearing registration number AS02DC 2675 were seized in connection with the said case. Learned counsel for the petitioner has submitted that later on, learned Judicial Magistrate First Class Dhansiri by order dated 25/8/2023 passed in GR case number 119/2023 had given the Jimma of the said vehicles to the present petitioner.
Dr. Here date is 19/9/2023, page 22, 19/9/2023.
19/9/2023. Jimma of the said vehicles to the now the petitioner apprehends that though their name has not been mentioned in the FIR, however, if as their vehicles were seized in connection with the Sungajan PS case number 12/23, they may be arrested when they appear before the investigating officer to get the custody of the seized vehicle. Stop. On the other hand, learned additional public prosecutor submits that though the present petitioners are not named in the FIR, however, the result of the case diary could be necessary. Hence, call for the case diary fixing.
Fixing, my lord. 11/12, my lord.
11/12 for the case diary. However, in the meanwhile, considering the fact that the petitioners are not named in the FIR, both the above named in the FIR, they are hereby directed to appear before the investigating officer of Sungajan PS case number 12/2023 and cooperate with the investigating officer within 10 days from the date of this order. Stop. If they do so within stipulated period of time, in the event of their arrest in connection with Sungajan PS case number 12/23, they shall be allowed to go on interim at bail of rupees 30,000 each with one surety of like amount subject to the satisfaction of arresting authority with following condition. This condition number 1 in both. Let the case be fixed again on
my lord, 11/12.
11/12 for case. I'm taking 2 minutes. Yes.
438 application, Your Lordship. FIR at page 7, Your Lordship.
Yes.
Your allegation is abatement of committing suicide, Your Lordship. Abatement of suicide. Page 7. Yes, sir. Merit.
Whether case diary would be required.
Required lordship, serious allegation.
My lord, deceased committed suicide at her own house, Your Lordship. Actually, it fact that, my lord, the family members of the deceased, my lord, assaulted her on the ground that she had a love affair with a boy, my lord. And due to assault committed by the family members itself. In the affair itself, it is stated, my lord, that she had committed suicide at her house in the council. But first part of allegation, my lord.
Then why are you first part? Read the FIR.
My lord. With due respect, we have to state that my younger sister, Miss Asanur Begum, alias Sahinur Begum, aged about 14 years, reading in class 9 years. The accused number 2, one of my neighbor, had given one mobile number transfer of his brother to my sister and suggested her to make love relation with his brother. The person of the said mobile number asked my sister to make love relation through SMS. But my sister informed the accused number 2 that she does not love him and asked not to send any SMS to the mobile phone. On 22/09/23 at about 11:45 a.m., my lord, the accused number 1 asked my sister to go with him and took her to his house. As my sister denied to make love relation with the said boy, the accused numbers 1, 2, 3, 4, and 5 have assaulted her by detaining inside the house. Upon getting such information,
Case diary would be.
I know this allegation of market committed by the accused person is absolutely false, Your Lordship.
Let us see.
My lord. In the meantime, my lord, some protection will be given, will appear before the investigation.
Not now, we are picking short.
Lordship.
Mr.
There.
A. Rahman, counsel for the petition. Also heard Mr. K. Bashir, additional public prosecutor. Considering the nature of allegations leveled against the present petitioners in the case that in the FIR, perusal of the case that is felt necessary for consideration of the instant bail application. Instant anticipatory bail application, hence call for the case that fixing
3011.
3011 for case that.
Item number 20.
May I please the lordship, my lord, 438 application, my lord. My lord, FIR page 8, my lord. The allegation, the petitioner is a driver, my lord. My lord, what happened on 2/11/2003, while one vehicle was tried to parking near for unloading some material for a shop repair, my lord. Suddenly the vehicle collided with a parked vehicle, my lord. That time some altercation took place between the drivers and the nearby people, my lord. And the shopkeeper, when he came out, my lord, he sustained injury, my lord, by the irritated driver, my lord. My lord, thereafter, the informant lost this case against 4 persons, my lord. This petitioner is one of them, my lord. The petitioner is standing nearby, my lord. He is not participating, my lord, but he was implicated in this case.
What injury was caused?
Injury, my lord, according to informant, my lord, he was sustained injuries on his left eye, my lord. Well, he may be protected, he will cooperate, my lord. Other 3% is also there, my lord. He will cooperate with the IO, my lord.
What happened to other 3%?
My lord, they were not, one person was named, but other 2% I do not know, my lord. This person is the second person, my lord, who is second person naming the
No.
applicant.
Now, what is the specific allegations against you?
Against, my lord, no such allegation, my lord, against the appendant, my lord, he named the person who involved in the incident, my lord.
What happened to his eye?
My lord,
Injured.
he was, I do not know, my lord, medical report maybe, it is called, my lord, medical report will say, my lord.
Lots of CD is required in this connection. Allegation is serious because using the sharp weapon
Yes,
and
my
by
lord.
using the brick is used.
We are fixing a short there.
My lord, in the meantime, he may be protected, my lord. He will cooperate, my lord. Other
Give a short dead lots. Witness regard to offense.
No, let us finish the case. We will
It
give
is
it short.
required.
Heard Mr.
as the
S. Das, learned counsel for the petitioner. Also heard Mr. K. Basho, learned additional public prosecutor. Considering the nature of allegations leveled against the petitioner in the FIR, perusal of the case diary is felt necessary for consideration of the instant bail application. Hence, call for the case diary fixing. Give a short.
Lots. 28 lots. 28.
Item number 24.
Fixing 20. 28.
Made to loss. But husband and wife, you lost. In the meantime, husband already arrested. Number 1 9. Main allegation against the husband. Page 11. This was filed during vacation, my lord. Ultimately, for some defect matter came today only. Then also he mentioned it also. So number 1 already arrested, you know, your lordship may know tonight. Therefore, number 2 is
Petitioner
concerned.
number 1 has been arrested.
Arrested on 31st of last month, September, after filing of this case. Now only matter I am for the wife. Number 1 is husband, number 2 is the wife.
What is the allegation against
Yes,
the wife?
allegation page 11, madam. This is regarding some dark, my lord, that your lordship can make to inform me that on last so and so, my husband Gyasuddin Ahmad was proceeding towards Bilashipaka market for purchasing sky sheet and other materials of the house constructed along with 50,000 rupees. But on the way to Bilashipaka in front of the house of the accused person, suddenly the accused person equipped with sharp cutting weapons attacked my husband with an intention to kill him. According to the accused number 1, stabbed in the belly, head, left hand, left neck, and other various parts of the body of my husband. At that time, the accused person number 2 was also cooperating and attacked my husband. So this is about accused number 2, my. When he went cry of my husband, nearby people came and saved life of my husband. After doing the illegal act, both the accused person fled away and cash amount of 50,000 was taken. This is the case. Now your lordship will find that I have stated my lord, just my lord, paragraph 4 of my petition, your lord. Family members, my lord, they are almost my page 4, paragraph 4. Just
Yeah.
the actual fact of the case, your lordship. The informant is the wife of the elder brother of the petition number 1. His own brother's wife, my petition number 1. While the petitioner 2 is the wife of petition number 1. Both the parties have been residing nearby each other. It does not state that both the parties got some boundary dispute which led to some sort of dispute occasionally. Prior to the alleged date of occurrence, that is on 17/8/23, some darks of the petitioners went to the petty field of the victim Gyasuddin. And that is why the victim came and shouted at the petitioners by using abusive language. Yet they did not protest, rather they assured the victim that they would control their dark. On the alleged date of occurrence in the morning, when the petition number 1 had been busy with his domestic works, the victim suddenly entered into the house of the petitioner, armed with a weapon with a view to kill the petitioner number 1. Thereafter, some altercation took place between the parties regarding entries of the darks and boundaries. In fact, except quarrel or altercation, no injury has been caused by the petitioner to the alleged victim, and if there is any injury, that may be self-inflicted to some injury. To the information of the petitioner, the cause for alleged admission in Kokrajhar Medical College and Hospital may be due to injuries sustained by the victim in some other incident subsequent to the alleged occurrence. Petitioner correctly stated that they have not committed the alleged offence, so and so. Now, your lordship, I am, since my wife, normally my husband, of course, some allegation against him, especially allegation against him. Wife, your lordship may consider subject to what he comes my allegation. Wife is mine, not against main allegation, not against.
Yes, there is no specific allegation. General allegation is there.
General allegation, but lordship is stated that there's a she is co-parting.
Apart from that statement.
Yes, she is co-parting. That is there.
Let her appear.
Yes, ma'am.
Because heard Mr. H.R.A. Chaudhary, learned senior counsel assisted by Ms. R. Deka, learned counsel for the petitioner. Also heard Mr. K. Bosho, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Jahanuddin Ahmed and Rashida Khatun, who are apprehending their arrest in connection with Kokrajhar PS case number 288/23. The gist of acquisition in this case is that on 19/8/2023, one Rofika Khatun had lodged an FIR before the officer in charge of Kokrajhar Police Station, inter alia, alleging that on 18/8/2023 at about 7:30 p.m. a.m., when the husband of the first informant, namely Giyasuddin Ahmed, was going to Vilasipara market for purchasing CI sheet with rupees 50,000 cash with him, he met the accused person on the way, and the accused person assaulted the husband of the petitioner, husband of the first informant, causing serious injury on her person, on his person. Stop. Learned senior counsel for the petitioner has submitted that in the FIR there are specific allegations against the petitioner number 1, who has already been arrested in connection with this case, and therefore his prayer for anticipatory bail has become infructuous. As regards petitioner number 2 is concerned, learned senior counsel has submitted that there are no specific allegations made against the petitioner number 2, and only a general statement has been made that she had cooperated with her husband in assaulting the victim. Stop. On the other hand, learned additional public prosecutor submits that considering the nature of allegations level in the FIR, perusal of the case diary would be necessary. Hence, call for the case diary fixing 7/12. However, considering the fact that the petitioner number 2 is the woman and there are no specific allegations leveled against the said petitioner in the FIR, and also considering the fact that the main accused in this case has already been arrested, the petitioner number 2 is hereby directed to appear before investigating officer of Kokrajhar PS case number 288/23 within a period of 10 days from the date of this order and cooperate in investigation. If she does so within the stipulated period of time, in the event of her arrest in connection with Kokrajhar PS case number 288/23, she shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following condition: that she shall cooperate with the investigating officer in the investigation of the case. She shall not directly or indirectly make any inducement, threat, or promise to any person who may be acquainted with the facts of the case, so as to dissuade such person from disclosing such facts to the investigating officer. Let this case be fixed again on
Seven.
7 February.
Made legal lordship, for 38 application. FIR is at page number 12, annexer. Operating party is at page number 14.
Page number 12.
Yes, sir. Operating party is at page number 14.
What is the allegation?
Made with the FIR. We, Badri Rai and Company, raised the purchase order to Blueberry Steel Concrete Private Limited, having addressed 37 to Diamond Group for an amount of rupees 2,15,94,000 for supply of hot roll section MSC U shape 6 meter length and hot roll section MSC U shape 8 meter length for ongoing our project construction of Majuli Bridge at Majuli. Accordingly, we have made payment of rupees 1,07,97,000 as an advance payment for the purchase order on dated 19/9/2023 and 26/9/2022. But the vendor has neither responded nor supplied the material from their end. That is the allegation. If your lordship peruse annexer E page number 19. Annexer E page number 19. This is the e-way bill for dispatch of a vehicle for supply of the materials. And annexer F is page number 20 is the tax input. And annexer G, page number 21. This is the acknowledgement received from Badri Rai and Company, that is the informant, that they have received the amount, the material. Only on a false allegation, they filed the FIR.
What material? Steel pipe.
Steel pipe. They've already received the material, half of the material, and the rest of the consignment are being prepared, but they have filed lost this false FIR. Annexer E is the e-way bill, and the annexer G, page number 21, that is the acknowledgement. Only on false allegation, the present petitioner has been named as an accused in the affair. He is the MD, Managing Director of Blueberry Group.
Why are you apprehending her?
Because his name has been there in the affair, and the police is constantly calling him. And yesterday, I have received the instruction that one of his account has been seized or freezed by the police. There is a apprehension that if he appears before the police, he may get it because of this false allegation.
Yes, Mr.
We have the documents. If we get the interim, then we will be able to appear before the police and we can show all these documents.
Lordship, it's a payment amount is rupees 1,07,97,000. A huge amount.
Maybe.
We have already, after the consignment has been sent to them.
But this appears to be a contract between the
Yes,
parties.
it is a civil matter.
Appears. Heard Mr. J.K. Bhuya, learned counsel for the petitioner. Also heard Mr. K. Bosher, learned additional public prosecutor. This application under section 430 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Sarfaraz Nawaz, who is apprehending his arrest in connection with Duliajan PS case number 258/2022. The gist of accusation in this case is that on 11/10/2023, one, what is the name of the informant?
Name of the informant is Parthopratim Adak.
Parthopratim Adak lodged an FIR before the officer in charge of Duliajan police station, inter alia, alleging that the company to which the informant belongs, namely Messrs. Badri Rai and Company, had raised purchase order to Blueberries Steel Concrete Private Limited. Who are you?
I'm the managing director of Blueberries Company.
Okay, Blueberry Steel Concrete Private Limited, for purchase of MS sheet hot rolled section, for supply of hot rolled section MS within inverted comma U shape 6-meter length sheets and other steel materials amounting to rupees 2,15,94,000, and it is stated in the FIR, out of the agreed amount, the informant had already paid an amount of rupees 1,07,97,000. However, the vendor has neither responded to nor supplied any material from their end. On receipt of the said FIR, Duliajan PS case number 258/23 under section 420/406/409 IPC was registered. Learned counsel for the petitioner submits that the petitioner is the managing director of Blueberry Steel Concrete Private Limited, and the allegations leveled against the petitioner's company in the FIR is false, as the petitioners have already part of the agreed materials to the informant's company, and rest of the materials are being in the process of dispatch. In support of his submission, learned counsel for the petitioner has furnished a copy of e-way bill which is annexed at Annexure E. Also furnished a copy of tax invoice which is annexed at Annexure F, as well as an acknowledgement receipt from the first informant's company, which is annexed at Annexure G to the petition, which shows that the petitioner's company had dispatched some of the articles agreed to be dispatched, and the acknowledgement receipt at Annexure G also shows that the receipt of the same by the informant's company. Learned counsel for the petitioner has also submitted that if the petitioner is ready to cooperate in the investigation and is ready to produce all the documents before the investigating officer. However, he is apprehending his arrest, hence prayer for anticipatory bail has been made. What is your submission? Let them appear. Let us dispose it of. Or you want case diary?
But the city is required, but the allegation is there might be some purpose. Interim may be there, but
Learned additional public prosecutor submits that considering the nature of, considering the amount of money involved in this case, perusal of the case diary would be necessary. Hence, praise for calling for the case diary. The prayer is allowed. Call for the case diary. Fixing
811.
811. However,
Sorry, 812.
812.
812.
So, however, considering the fact that from the documents annexed along with the bail application, it appears that the petitioner's company had already dispatched part of the agreed items to the informant's company, comma, the petitioner is hereby directed to appear before the investigating officer of Duliajan PS case number 258/2023 within a period of
1 week.
10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, comma, the petitioner shall be allowed to go on bail of rupees, interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with a condition that he shall cooperate in the investigation. Let this case be listed again on 8/12.
Supplementary list for motion item number 49.
May it please the lordship. It's a 438 application, my lord. The lordship will find the FIR at page 7, my lord.
Yes.
Informant humble submission is that on so and so at about 9:30 p.m. at night, while the truck bearing number so and so was proceeding from Guwahati to Delhi, loaded with 425 bags supari, reached at Borpeta Road, Simuniguri. Some unknown miscreants stopped the truck in the said place, and thereafter they pulled down the driver and handyman from the truck and committed market with them and threatened them with dire consequence and rope up them and get them on a small car, taken away 382 bags supari from the truck, and thereafter they left them along with the remaining 43 bags of supari and the vehicle, my lord, near College so and so. Here, my lord, in this case, my lord, page 13, your lordship will find, my lord, 7 persons have been arrested, my lord. Page 1. 7 persons have been arrested, my lord. Now, last name, my lord, number 7, my lord, Azizul Haq, my lord. My lord, he is my uncle, my lord, and we reside in the same premises, my lord. That's why police is coming to my residence, my lord. He is my uncle, my lord. I am no way related in this case. Now, if your lordship sees this forwarding report, my lord, next page, my lord. On the first paragraph, my lord, during investigation, visited the PO of this case, complaint, and victims were examined, and the statements were recorded. Later upon, on confidential sources information, the arrested accused persons were apprehended, and on examination, they admitted the involvement in the entire case, crime of the case, and in course of the further investigation, 227 bags of dry areca nut, cash rupees of so and so, bill of so and so, are recovered from the possession of the above mentioned accused. My lord, here, my lord, I am apprehending, my lord. I have made a specific categorical statement at paragraph 4, my lord, page 3, my lord. It is stated that although the petitioner is not implicated in the aforesaid of police, has been searching for the petitioner by visiting his residence. Hence, he is apprehending to be arrested in this case.
Yes. But it is a case of dacoity. We, he is not named in the FIR. In forwarding also he is not named. What was the FIR? How many accused persons?
FIR, my lord, no name, my lord. No name.
Numbers of
Numbers also, my lord, nine, 7. No, my lord, no.
some unknown.
Some person.
There is a probability that you may also be involved. And co-accused might have named you. But nothing is there.
Nothing is.
Because Lordship, investigation is in the nascent stage. Investigation is going on.
Let us call for the case diary. Why police is going
mad?
Fixing a short date.
In fact, my lord, today is more than 1 month. They were arrested on 11/10/20.
When police last visited you?
That specifically I cannot say, my lord, to be honest, my lord. If your lordship sees, my lord, the forwarding also.
There is nothing mentioned.
Nothing, my lord. And in fact, my lord, there is one line, my lord. Page 14, my lord. Ground of police remand, my lord. Lordship may see the bold letter, my lord. Ground of police remand. Lordship has seen, my lord.
Yes.
Serial number 3, my lord. The recovered money was obtained by the accused person by selling the looted nurse. On examination of the accused person, it reveals they sold a part of the looted articles of rupees so and so to someone, out of which 9 lakhs were distributed to one Mistri, Jamir Ali, Rezak Bhuiya, Halim. And the word, my lord, others is there, but their names were specifically stated. I am not one of them, my lord. That's why, my lord, I am praying for interim.
Lordship, in the same grounds of police remand, in the para 1, Lordship, for further investigation of the accused person to catch other accused person.
Yes,
But other accused names
their
are
name is not there.
no, names are mentioned
Names are mentioned.
in 3. His name is not.
His name is not there.
Let him appear. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K. Bhusha, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Nurul Islam, who has been apprehending his arrest in connection with Sorbho PS case number 107/2023 under section 342/394/395/412/413 of the Indian Penal Code. The gist of accusation in this case is that on 5/10/2023, one Shri Kailash Mandal had lodged an FIR before the officer in charge of Sorbho Police Station, inter alia, alleging that on 4/10/2023 at about 11:30 at night, when the informant was proceeding from Guwahati to Delhi in a truck bearing registration number RJ21GD3892, carrying 425 bags of supari, and when they reached Borpeta Road, Similaguri, some unknown miscreant stopped the truck and assaulted the driver and the handyman, and thereafter looted the the 382 bags of supari, which was carried by the said, which was there. 82 bags of supari out of 42, 425 bags of supari, which was being carried by the in the said truck. Learned counsel for the petitioner has submitted that the petitioner is no way involved in the offense alleged in FIR. Learned counsel for the petitioner has also submitted that in connection with the instant case, 7 numbers of accused persons have already been arrested by police, out of whom and out of these 7 numbers of accused persons, one Azizul Haq is also there, who is the uncle of the present petitioner, and with whom he used to stay in rented or owned
Same premises.
in the same premises. The petitioner has submitted that after arrest of his uncle, the police has come to his residence searching for the present petitioner, and therefore he apprehends that he may be arrested in connection with this case. Learned counsel for the petitioner has also submitted that while seeking remand of the arrested accused persons, the IO, the investigating officer, has also named some other accused persons who are yet to be arrested. And out of those named accused, the name of the present petitioner does not figure. And therefore, the learned counsel for the petitioner submits that the petitioner is no way involved in the offense alleged in the instant case. It is also submitted that the petitioner is ready to cooperate with the investigating officer. On the other hand, learned additional public prosecutor has submitted that since the offense of dacoity is involved in this case, perusal of the case diary would be necessary. Hence, call for the case diary fixing.
8-12.
8-12 for the case diary. However, in the meanwhile, as at present, there appears to be no material on record against the present petitioner, and he is ready to cooperate in the investigation, the present petitioner, namely, what is the name? Namely, Nurul Islam, is hereby directed to appear before the investigating officer of Sorbhog Police Station case number 107/2023 within 10 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Sorbhog PS case number 107/23, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority. Let this case be fixed.
8-12. I am obliged, my lord.
For motion, production list item number 1.
The admission will not be serially material.
Here probably their office has not sent the file. So may I say that this matter will be taken up at 2 load. Probably their file is not here. No, at 2 load.
For admission item number 26.
Please, your Lord. Lordship, as per the office note dated 31/7/2023, the service for respondent number 2 is completed.
Respondent number.
Respondent number 2.
Yes. What is the matter?
Lordship,
Will it require hearing?
Yes.
Full length hearing?
Yes.
Then
Lordship, but
we'll take it up after bailment.
okay, no, Lordship, there is one issue here. On 28/2/2022, the scanned copy of the case diary was called for, but it has not reached, and the matter
would
cannot
be
be
required.
executed without that. Actually, there is urgency in this case because I have cleared the APSC mains, and in the month of December, I'll be having my viva. So the matter may be taken up in the coming week with the city, with the scanned copy of the case diary.
Mr.
G. Kaushik.
G. Quashing, learned counsel for the petitioner. Also heard Mr.
B. Sharma.
B. Sharma, learned additional public prosecutor. Learned counsel for the petitioner submits that the office note dated. Which office?
31/7/2020.
No, it appears from the office note dated 31/7/2023 that the service, that the notice, that the service report in respect of respondent number, in respect of notices issued to respondent number 2 has been received, and it appears that the notices are duly served on the said respondent. However, no one appears for the respondent number 2. What is the matter here?
Quashing of an FIR in page number 19.
No one has appeared. Stop. However, learned counsel for the petitioner has submitted that the case diary, that the scan copy of the case diary of Gitanagar PS case number 137
My lord.
2017, which was called for, has not yet been received, and same would be required for proper adjudication of the instant criminal petition. Stop. Considering the submissions made by learned counsel for the petitioner, issue reminder for case diary. Who will produce the case?
My lord, in the earlier it was scan copy, my lord. It was generally scan copy for registry. If the original is required, I will produce the case diary, my lord.
When the FIR was
Page number 17. 16/4/2017.
okay, call for the case diary. Right. The learned additional
My lord.
public prosecutor
My lord.
shall ensure the production of the case diary
My
on the
lord.
next day fixed.
Actually, can we have it on 24?
He will, when can you produce?
My lord, from Gitanagar, my lord. It is, what is it? 24. 10, my lord. We'll try, my lord.
Let this case be fixed on 24/11/2023 in admission column.
My lord.
Item number 28.
Lordship, I'm for the respondent number 8, Lordship. Kindly Metro may possible 40 day, Lordship. As my senior had to leave, Lordship, due to his some personal urgency. P. Das, Lordship.
Ms. P. Das, learned counsel for respondent number 8, who prays for an adjournment on the ground of personal difficulty of learned, personal difficulty of her Senior will be engaged counsel for respondent number 8. Also heard Mr.
Lordship, I am appearing for the state of Arunachal, Lordship. We will be needing, Lordship, 3 weeks time to file our affidavit, Lordship.
Time to file.
Affidavit, Lordship.
Okay. Who is for the petitioner?
I'm for the petitioner, Lordship.
Also heard Mr.
B. Borgohain.
B. Borgohain, learned counsel for the petitioner, as well as Mr. A. Chandran, learned additional senior government advocate, Arunachal Pradesh, who prays for
3 weeks.
3 weeks time for filing affidavit in opposition. The prayer is allowed.
Interim order is there.
Interim order is there. Let this case be listed after 3 weeks. The interim order shall continue till next day.
Much obliged.
You are also there.
Yes, I am 40, one.
Mr. D. Nath. Am I right?
Yes.
Mr. D. Nath, learned senior government advocate, appears for respondent number 1, 2, and 3.
Our role in this case is very limited. It is basically the.
Okay. Only show his presence after 3 weeks.
Much obliged.
Item number 29.
Same, Lord. 29, same. Same, Lord. 29 also.
29 also.
We are for respondent number 8.
29.
Lordship, matter may be remanded back to the JGP and let him decide the juvenility, Lordship.
Now, who is for the petitioner?
I am for the petitioner, Lordship.
You will be filing.
Lordship.
Let them file the.
Lordship.
Heard Mr. B. Borgohain, learned counsel for the petitioner. Also heard Miss, what is your name?
P. Borua on behalf of
P.
BP.
Borua, learned counsel for respondent number 8. Also heard Mr. D. Nath, learned counsel, learned senior government advocate, appearing for respondent number 1, 2, and 3. And Mr. A. Chandran, senior government
Additional.
Additional senior government advocate, Arunachal Pradesh, appearing for respondent number
4, 5, 6, and 7.
4, 5, 6, and 7, who prays for 3 weeks time for filing affidavit in opposition. The prayer is allowed. Let this matter be listed after 3.
But the interim order was there.
The interim order shall continue.
Okay.
Much obliged.
Bail hearing B, item number 50, part head matter.
Arun, it has really after this.
Lordship, item number 50, I guess, special PP, Mr. M. Haller for severe, he is in the hospital due to his mother's sudden illness, Lordship. So the matter may be fixed at 2 p.m. Lordship.
Today.
At
Yes,
2, Lordship.
At 2 p.m. Lordship. He will be available.
Okay.
Okay.
Item number 31.
31 also, Lordship.
31, my lord, today they have filed one objection against my bail prayer, my lord. That may be called for, my lord.
Written objection, we have filed, Lordship.
Otherwise, my lord, lordship may fix it on Monday, my lord.
Heard in item number 31. Item number 31. Heard Miss
T. Begum, Lordship.
P. Begum appearing for
Lordship, this matter may fix at 2 p.m. He will be available. He, special PP will inform court, Lordship.
Okay, let it be called at.
My
Yes,
lord,
Lordship.
my lord, because my lord, same affair, 50 and 30.
Okay.
Yeah.
Oblige, my lord.
Obliged.
Here, lordship, charge sheet submitted.
Heard Mr. H. Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. B. B. Gogoi, learned additional public prosecutor, who has submitted that though the case diary was called for in connection with this case, However, in the meanwhile, the investigating officer has laid the charge sheet bearing charge sheet number
440/23 dated 31/10/23.
in view of the laying of the charge sheet in this case. This bail application is hereby disposed of with an observation that the petitioner may approach the trial court and pray for regular bail there, if so advised.
Bill shall be considered.
It will be considered.
Merit of the case.
Dear Lordship, initially one FIR was lodged, and after investigation, police submitted charge sheet. And after submission of charge sheet, trial proceeded. In the charge sheet, 5 witnesses were named as witness. Lordship will find in the charge sheet that page 17. 5 witnesses were named. Page 17, your Lordship will find.
70.
17.
Yes.
Ranjit Singh, Jamiruddin Talukdar, Noor Haq, Sarfaraz Alam, and Giyasuddin Ahmed, 5 witnesses. And after conclusion of 5 witnesses, Lordship, the trial court found that another witness is necessary for judge decision of the case. Accordingly, he was called, and he is examined as PW6. Page 41, your Lordship will find. At that time also, the accused side did not raise any objection to that, Lordship, because it was necessary for the judge decision. Page 41, page 6. Chandan Das, he is not a cited witness, but court called him and he was examined. Now what happened, Lordship? After examination of this witness, when the evidence was closed, their 313 were also recorded. Page 43, your Lordship will find. And just one thing I'm pointing out again, Lordship. Page 41, your Lordship will see that last witness was examined on 13/12/2022.
Yeah.
Page 41. So thereafter, Lordship, that 313 was recorded. Page 43, your Lordship will find. And now prosecution has filed one application. That application, your Lordship will find at page 81. 81 type copy and vernacular 83. May I read their application? Page 81. Page 81.
Yeah.
Sir, the petitioner, public prosecutor on behalf of the state most respectfully begs to state that the above noted case is fixed today for argument. That in the above noted case, there are 6 numbers of witnesses were already been examined from the prosecution side. The below named witness number PW5, SI Molin Bora, who is an investigating officer in the case, has been examined. But during his examination, some of the fact has not cleared, and to arrive at the judge decision of the case to clarify this fact, his re-examination is highly essential. That the defense side will get sufficient opportunity for further cross-examination of the witness before the court if the Honorable Court allowed the same, and there will be no prejudice on the part of the defense side. That the prosecution have not filed this petition to follow up the lacuna on the part of the prosecution, but it has been filed to just arrive at the decision of the case for the ends of justice. That the witness is the material witness and his evidence for re-examination of highly essential to clarify some ambiguity of the interest for the interest of justice. The prosecution side will not take much time and will able to produce the witness positively on date fixed if the Honorable Court allowed the petition. It is therefore paid. So from this application also what I find, they want to clarify certain aspects. And if your lordship now kindly turn to page 86, this is the impugn order. Their petition and their submission are not connected, lordship. Page 86, lordship may kindly see, I am reading. The case speaks accused Zubair Longsong. Learned counsel for the accused Zubair Ahmed has filed petition objection. The last paragraph I am reading, lordship, page 86. By the aforesaid petition, the learned public prosecutor has paid for re-examination of the PW5 SI Molin Bora, who was the investigating officer in the said case. During the course of hearing of the petition, learned public prosecutor has submitted that certain material documents, including authority letter, has not been brought on record, which is required for proper adjudication of the case. This is not mentioned in the application, lordship. They said certain aspect is required to be clarified. Now they are saying about documents. The learned counsel for the accused person have vehemently objected to the said prayer stating inter alia so enough opportunity was given to the prosecution and they cannot. Now, lordship may kindly see the last paragraph of page 87. Considering the aforesaid submissions and the fact that certain documents and relevant materials have been left out which are required for proper adjudication of the case, this court is of the considered opinion that the prayer under section 311 CRPC may be allowed. There is no mention about producing document in the lordship that their application. And while submitting, they said that some documents is required to be produced. Now, my submission to your lordship is that they have to furnish copies under section 207, the documents which they want to rely. They have not submitted those documents to me. Now, even in the petition also, they have not clearly said what document they want to produce and what why the re-examination of PW5 is required. That is not clarified. And in this respect, lordship, just I am relying on a judgment of our High Court. That they have to give the reasoning that why that is required, lordship. Paragraph 18 and 19, lordship. It will be page 3, lordship. Third page. Down below, page 8, paragraph 18.
Para
18.
1A.
1A. The in between, in middle portion, your lordship will find first page, second page, third page, lordship. Paragraph 18. May I read?
Yes.
Considering the aforesaid observation, the trial court probably passed the impugn order. There is no doubt that discretion given to the court is very wide and such discretion also requires a corresponding caution. When a court passing order in a case is in argument stage, the court is to see whether at that stage, if any order is passed, that would cause any prejudice to the accused. Here also my case is fixed for argument, lordship. 313 was over. We have also filed written argument also in this present case. In the instant case, it appears from the record that though the PP asked for examination of Deputy Inspector of School, re-examination of PW1, which prayer has been rejected by the trial court, and also for recalling of the Exhibit 37, he nowhere stated the reasons for such examination of the Deputy Inspector of School and recalling of the aforesaid documents. More so, the said document is not the part of the police report and the petitioner being the accused was not provided with the copy of such record at the initial stage. Therefore, it would obviously prejudice the said petitioner as defense has disclosed its case, more particularly adduce the evidence in support of its case. Here I have already submitted my written argument also. And they are not disclosing even then what document they want to adduce. And now paragraph 19 important.
Now, how it would prejudice you?
Yes, because I have already cross-examined the witnesses in this regard.
You can again cross-examine.
No, but that will prejudice me, lordship, because they have only asked for PW5, lordship. then the entire case has to be restarted, Lordship. Because if they produce one document, then I have to probably maybe required to examine other official witnesses also. And because in the petition they have not said anything why his re-examination is required. Paragraph 19 for a moment, Lordship.
Yes.
Taking note of the fact that IO of the case when stated in his cross-examination that he could not detect as to who had submitted the certified copy of the order date censure, it would in no way help the prosecution case even on submission of the said record when according to the court below the said document is a forged one. One of the court should then the court should take action in accordance with law against the person who submitted the said document before the court. Or the court can inform the High Court to take action against the person who obtained the certified copy. The last 4 lines, Lordship, of that paragraph 19. Therefore, according to this code, though the learned special judge has the power to examine and re-examine of recalling the witnesses already examined under section 311 of the CRPC at any stage of the inquiry or trial. But this is not a fit case where at this belated stage and witness can be examined, which would ultimately frustrate and prejudice the case made out by the defense. And in similar line, Lordship, I am relying on another judgment of Honorable Apex Court, Lordship. Because of delay filing in this application, it was rejected. And I have placed your Lordship that PW51.
Application for what? Same for production of document.
No, delayed application of under section 311.
Okay.
Here also, Lordship, the PW5 was examined in November 2022. And he is not yet appeared in November 2023, Lordship. And paragraph 12 and 13, Lordship, may I kindly see? 12, Lordship, I am reading. It is well settled that the power conferred under section 3.
Yeah.
It is well settled that the power conferred under section 311 should be invoked by the court only to meet the ends of justice. The power is to be exercised only for strong and valid reasons, and it should not be exercised with great caution and circumspection. The court has wide power under this section to even recall witnesses for re-examination or further examination necessary in the interest of justice, but the same has to be exercised after taking into consideration the facts and circumstances of each case. The power under this provision shall not be exercised if the court is of the view that the application has been filed as an abuse of the process of law. Now, paragraph 13, Lordship, where the prosecution evidence has been closed on examination of the witnesses, a witness earlier is not satisfactory. The summoning of the witness at belated stage could cause great prejudice to the accused and should not be allowed. Similarly, the court should not encourage the filing of successive applications for recall of a witness under this provision. So already PW6 was examined. Till then, they have said nothing. And when I have filed my written argument, they filed this application under section 311 without disclosing what document they want to furnish, why it is his examination is required.
Yes, Mr. Gogoi.
Yes, Lordship, if my lord, they try to fill up lacuna, then my lord, it is that petition should not be allowed, my lord. If my lord, some other
Who is
reason.
respondent number 2?
He is informant ISI, Lordship. My client PP can appear because he filed the case on behalf in his official capacity, Lordship. Page 13 is the FIR.
Yes.
Yes, what type of new papers, my lord, they want to produce? That is not clear in the petition, my lord. That is page 81. My friend has annexed, my lord, in his petition. If, my lord, that public prosecutor re-examine the IO, my lord, that they will get sufficient opportunity to cross-examine. I think, my lord, it will be not hampering the justice, my lord. Because he will get that opportunity to cross-examine.
No, we have already cross-examined in a direction, Lordship, where but by perusing the documents which are furnished to us under section 207. These are the already those documents were furnished to us, and after going through those documents, the engaged counsel cross-examine in a direction, Lordship. Now they want to produce new documents.
No,
Lordship.
the trial is that argument.
Argument already written argument filed,
Now,
Lordship will
suppose
file.
if we interfere,
Lordship.
if we have to decide the contention raised by
Lordship.
the trial, there would be put at halt.
No, then it will proceed from argument stage, Lordship.
No, it will proceed from argument stage only if we allow your prayer.
Lordship.
Whether it can be considered today itself, whether without perusing the record.
Well, that record will be necessary. But till then, some protection will be given because the matter is fixed on 17th. Day after tomorrow.
The 311 says that at any stage.
No, we'll decide it.
Yes,
Finally,
yes,
we'll decide.
yes.
Heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 401 of the Code of Criminal Procedure, read with section 401, 482 of the Code of Criminal Procedure, 1973, along with Article 227 of the Constitution of India, has been filed by the petitioner Long Song Rong Han, impugning the order dated 3/11/2023, whereby learned special judge, Shankardev Nagar Hojai, passed by learned special judge. What was the time? Not whereby. In number 24/21 under section 22C of the NDPS Act, 1985. Whereby learned special judge has allowed the petition filed by learned public prosecutor for recalling the PW5 in the said case. Learned counsel for the petitioner submits that the petitioner is facing a trial before the court of learned special judge, Shankardev Nagar Hojai, in special case number 24/21 under section 22C of the NDPS Act, 1985. And total 5 numbers of witnesses were shown as listed witness in the charge sheet. Learned counsel for the petitioner has submitted that after completion of the examination of listed witnesses, the prosecution side filed a petition for examining another unlisted witness.
Here, Lordship, application was not filed. Court on its own called this.
No. After examination of the listed witnesses, learned trial court examined one Chandan Das as PW6, though said witness was not named in the charge sheet in column number 6. Column number, where is the charge? 6.
Page 17 is the charge sheet, column number. Column number 6, Lordship,
column
page
number 6
21.
of the charge sheet. So, learned counsel for the petitioner has submitted that when the case was fixed at argument stage, the public prosecutor on 6/10/2023 filed another petition under section 311 of the Code of Criminal Procedure for re-examination of PW5, that is name PW5, namely Shri Malin Bora, SI of Police, on the ground that to arrive at just decision of the case and to clarify the facts, the re-examination of said witness was necessary. And thereafter, you objected to this.
Yes, I have filed objection.
The petitioner side filed objection against the said petition. However, by the order dated 3/11/2023, learned trial court allowed the said petition, and while allowing the said petition, it was observed that certain material documents, including the authority letters, has not been brought on record, which is required for proper adjudication of the case. Stop. Learned counsel for the petitioner has submitted that the ground on which submitted that though in the impugn order, the trial court has mentioned about documents to be produced by the witnesses who is sought to be recalled. However, no mention about said documents was made in the petition which was filed by the public prosecutors under section 311 on 6/10/2023. Learned counsel for the petitioner has also submitted that the petitioner would be highly prejudiced if the prosecution side is allowed to re-examine the PW5 after disclosure of defense by the petitioner side. It is also submitted that the said petition has been allowed by learned trial court belatedly, and which should not have been allowed. And in support of the contentions made by learned counsel for the petitioner, he has cited a ruling of Honorable Apex Court in Swapan Kumar Chatterjee versus Central Bureau of Investigation, reported in
2019, volume 14, SCC 328.
328. Wherein it has been observed as follows. Code para 12.
12 and 13.
Code para 12 and 13 from that. Stop. Learned counsel for the petitioner has also cited a ruling of this court in Jogen Bora versus State of Assam, reported in
It will be criminal revision petition number 28 of 2020.
28 of 2012, reported in Manu, capital MANU /GH/0089/2018 in support of his contention. On the other hand, learned additional public prosecutor submits that even if the prima facie, it appears that the Prima facie, from the materials available on record, it appears that the petitioner would not be prejudiced as he would get ample opportunity of cross-examining the witnesses, even if they are who are allowed, who are sought to be re-examined by the prosecution side. Stop. However, comma, not how. Stop. I have considered the submissions made by learned counsel for both the sides. It appears that the contentions raised by learned counsel for the petitioner need to be decided, and it would require going through the case records. Hence, call for the case record. Hence, call for the scanned copy of the case record of special NDPS case number 24/2021. The registry shall take steps for requisitioning the scanned copy of the case record of NDPS case number 24/2021. Fixing.
Yes. Registry.
Fixing 20.
Registry, I mean.
20 days there, 20 days there.
Yes, then first. Yes.
Fixing 15/12 for case record. However, as the case has, as the special NDPS case number 24/21 has already been fixed for examination of the recalled witness on 17 November. 17 November 2021. And waiting for arrival of the case record till 21/12/22 without issuing any interim, without issuing any abeyance order would make this criminal petition infructuous. Hence, till arrival of the case, scanned copy of the case record, the impugn order dated 3/11/2023 passed in special NDPS case number 24/2021 by learned special judge Hojai is kept in abeyance. So issue notice to the respondents as learned additional public prosecutor has appeared for both the respondents. No formal notice need to be issued to the respondent side. Let this case be fixed again on 15/12 for scan copy of the case.
Wait, Your Lordship. On the other day, Lordship has heard the matter almost. The matter, Lordship.
In this case, assuming that the investigation is completed,
Then he is not entitled.
he is not entitled to statutory bail, assuming, only assumption.
Yes, sir.
Then also whether he is entitled to get bail otherwise, because his case has not been committed on repeated dates, on successive dates by the learned committal court. And his case is not proceeding further. So whether on that ground you are praying for bail only on one ground.
Only one ground, default.
Only default.
Under 439 read 167 2. So regular bail will come under 439 Lordship.
No, that is my additional query to you.
Lordship.
Suppose this court comes to a finding that the investigation
Is complete.
is complete, then the consequence would be the petitioner would not be entitled to 167(2) bail, default bail. But otherwise,
439.
439 bail. On that, what is
Yes.
your submission?
Also, there will be, if the court finds that
Because his case is not being committed on how many dates?
Lordship, since Lordship 29.
Several dates.
Seven.
On several dates.
right.
29.
Lordship, otherwise, if your lordship have to see the merits of the case, then
Not on
gravity of
merits.
the gravity of the offense and all, your lordship.
No, otherwise, why do you require his custodial detention?
Custody, because further investigation is going on. He may hamper the further investigation of this case because there are analogous cases.
But his trial is also not going on.
Trial will commence, lordship, because we have submitted the charge sheet and cognizance has been taken, lordship. We have submitted the list of witnesses.
Further investigation is going on in which matter?
Lordship, regarding the collection of the CDR report from the Forensic Science Laboratory, and some witnesses have already been examined, lordship. We are going to file the supplementary charge sheet, lordship, with regard to those statements.
That is where Lordship, the role of the other accused person named in the FIR was not Lordship ascertained at the time of filing Lordship charge sheet. So in that way also, Lordship, it cannot be said that investigation is complete, Lordship, because role of the other co-accused was named in the FIR was not ascertained. They are very much accused in this case, Lordship. So that language of the IO, Lordship, Lordship again kindly come to page 45. For a moment, Lordship.
Lordship, we have already argued
Lordship.
on this point. Now only the law point we should argue, Lordship.
Yes, Lordship. Only one point, Lordship. Lordship may kindly come to page 45. Only one point I want to add, Lordship. That paragraph 16.16. Page 45.
45.
16.16.
Yes.
That in this case, further investigation has been kept open to unearth larger conspiracy and role of accused. Mustaq Ahmed is FIR named accused, Lordship. Mukhtar Hossain, FIR named accused. Nazrul Islam, FIR named accused. Dildar Hossain, he was not FIR named accused. He was released on bail, Lordship. So these three, 1, 2, 3, they are FIR named accused. And the role of those accused persons was not ascertained, could not be ascertained at the time of filing of the charge sheet. So how the IO can say that that investigation is complete with respect to the offense? Explicit language used by the IO. My humble submission is that till the time of filing this charge sheet, investigation with respect to the offense was not complete. That's my point, Lordship. And otherwise also, Lordship, under 439, I am entitled to regular bail, Lordship. 439 as well as 162.
He may take because he is detained.
Yes.
He will try all his best,
Yes.
all his efforts to get out.
Right, Lord.
And Lordship, till today, 173 days in custody from the date of remand, Lord.
Yes, Mr. Halloway.
Lordship, I'll place three judgment.
Yes.
Supreme Today, Lordship, 2023 AIR ST 1901. I'll read
You are
only
furnishing the copies.
Yes, I'll furnish the copy also, Lordship. But right now I don't have all the copies, Lordship. I can furnish only later on, Lordship.
You give the citation, Supreme Today.
2023 AIR ST 1901.
Yes.
This is Lordship Umar Ghani Usmani versus State of Gujarat. I'll read only the head note, Lordship. Default bail denial. While considering the application by investigating agency for extension for time for completing investigation beyond the period prescribed under section 167(2) of CRPC, accused is to given notice and or is to be kept present before the court so that the accused had knowledge that extension is sought and granted. In the present case, for whatever reason, accused was not kept present at the time when the trial court considered report submitted by IO for extension of time for completing investigation. However, accused came to be informed about extension on the very next day. Accused did not challenge extension on the ground which may be available to him. At the time when the present application for default statutory bail was made, there was already an extension of time by the trial court charge sheet has been filed within period of extension, accused is not entitled to be released on statutory default date. He is required to challenge the order of extension. Here also same thing happens for him. The order passed by the learned CGM court is still in force with regard to the extension of time, with regard to the taking of cognizance. They are not challenged. So they are not entitled for the default bill. The next is Dinesh Dalmia, Lordship is well acquainted with the law, Lordship. Dinesh Dalmia, Lordship.
Dinesh Dalmia, which point you are?
Dinesh Dalmia, Lordship, with regard to the further investigation, Lordship, para 20, para 22, 24, 25, 38, and 39. These are the.
No. Dinesh Dalmia speaks about many things.
Speaks about, Lordship, the.
What are you emphasizing?
Lordship, regarding the power of investigating officer for further investigation. That is there. Even after filing charges, IO can file petition, or without filing petition also, they can carry out further investigation of the case. It is clear in the.
No, that on that aspect, we don't have any doubt.
Lordship.
Here we are concerned with only one issue, whether the investigation was completed when the charge sheet was laid.
Lordship, immediate investigation has to be completed before
No,
filing.
whether
That
in
is the
fact it
language of the code, Lordship. That is the language of the code. That is the language of 173, Lordship. Without investigating the, without completing the investigation, IO cannot file charge sheet, Lordship.
But suppose he files the charge sheet.
Then,
Suppose
then he will have to challenge it immediately that the charge sheet is
no,
not valid.
my query is
Lordship.
the court says that unless investigation, the charge sheet may be filed only on completion of the investigation.
Right, Lordship.
Suppose in a given case, investigating officer files charge sheet without completing the investigation.
That cannot be, Lordship. That cannot be, Lordship. Once filed, once it is accepted, it is an charge sheet, Lordship.
So is it your submission that once charge sheet is filed,
and it is
we
accepted,
have to deem it that the investigation has been
completed? Once charge sheet has been filed, and once the criteria laid down under section 172 has been complied with, then it is deemed to be that charge sheet has been filed. They can say that it is not a complete charge sheet. Then immediately they are required to.
There are many things, many issues.
Lordship.
Whether one issue is whether a report submitted by the IO under 173, even if some further investigation is required, may be regarded as a charge sheet or not.
Yes,
that is not the query before this court.
Not.
Query is whether the charge sheet which has been submitted after completion of the investigation. Suppose it
after completion of investigation.
If it is filed without completing the investigation, still it may be regarded as a charge sheet there. But then he will get the benefit of default pay.
Now,
if it is without completing the
completion of investigation, when we can assume or presume that investigation is complete.
Yes, on that you have
that for that we can say that the investigation is complete when the evidence required, when the testimony required, oral or documentary, has been submitted before the court at the time of filing the charge sheet or not. Here in this case, Lordship, charge sheet clearly shows that the documents which has been collected during investigation and the statement of the witnesses which has been recorded by the IO during investigation has been submitted, Lordship. And all the criteria laid down under section 173(2) has been complied with. Therefore, it can be said, Lordship, that investigation is complete against the accused person.
Okay.
Lordship, I'd like to lay down one more judgment of Honorable High Court. Sorry, High Court, Delhi High Court, Lordship. I'd like to read out, Lordship, the relevant
citation.
Citation is, Lordship, bail application number 2698/2023, Delhi High Court, Lordship. Was passed on 15 September 2023.
Who are the parties?
Parties, Lordship, Sanjay Kumar Kundar, Pundir, Pundir, Pundir versus State of NCT of Delhi.
What it says.
Lordship.
Which are the relevant paragraph?
Para 16, Lordship. Para 16. Here also, Lordship, they have relied upon that Dinesh Dalmia case, Lordship. A charge sheet is a final report within the meaning of section 2 of section 173 of the code. It is filed so as to enable the court concerned to apply its mind as to whether cognizance of offense thereupon should be taken or not. The report is ordinarily filed in the form prescribed thereof. One of the requirements for submission of a police report is whether any offense appeared to have been committed, and if so, by whom. In some cases, the accused have not been arrested, and the investigation against him may not be completed. There may not be sufficient material for arriving at a decision that the absconding accused is also a person by whom the offense appears to have been committed. If the investigating officer finds sufficient evidence even against such an accused who had been absconding, in our opinion, law does not require the filing of the charge sheet must await the arrest of the accused. Same fact, Lordship. Same fact. Indisputably, the power of the
read this line again.
Lordship.
Read this line again.
May I read the whole paragraph again, Lordship, so it will be more clear, Lordship. A charge sheet is a final report within the meaning of subsection 2 of section 107(3) of the code. It is filed so as to enable the court concerned to apply its mind as to whether cognizance of offense thereupon should be taken or not. The report is ordinarily filed in the form prescribed thereof. One of the requirements for submission of a police report is whether any offense appears to have been committed, and if so, by whom. In some cases, the accused having not been arrested, the investigation against him may not be complete. There may not be sufficient material for arriving at a decision that the absconding accused is also a person by whom the offense appears to have been committed. If the investigating officer finds sufficient evidence, even against such an accused who did not abscond, who had been absconding, in our opinion, law does not require the filing of the charge sheet must await the arrest of the accused. Indisputably, the power of investigating officer to make a prayer for making further investigation in terms of subsection 8 of section 173 is not taken away only because a charge sheet under subsection 2 thereof has been filed. A further investigation is permissible even if an order of cognizance of offense has been taken by the magistrate. It is well settled, Lordship, this is not taken. The statutory scheme does not lead to the conclusion in regard to an investigation leading to filing of a final form under subsection 2 of section 173, and further investigation contemplates under subsection 8 thereof. Whereas only when a charge sheet is not filed and investigation is kept pending, benefit of proviso appended to subsection 2 of section 167 of the code would be available to an offender. Once, however, a charge sheet is filed, the said right ceases. Such a right does not revive only because a further investigation remains pending within the meaning of subsection 8 of section 173. Now, lastly, Lordship, this is again Suresh Kumar Bhimchand Jain versus State of Maharashtra. This judgment has been relied upon while passing this judgment. In paragraph 16 of that judgment, in this juncture, we may refer to certain dates which are relevant to the fact of this case, namely, some dates has been referred. The petitioner arrested and remanded to police custody on 11/3/12/2020. From the above date, it would be evident that both the charge sheet as also the supplementary charge sheets were filed within 90 days from the date of petitioner's arrest and remand to police custody. It is true that the cognizance was not taken by the special court on account of failure of the prosecution to obtain sanction to prosecute the accused under the provisions of PCA, but does such failure amount to non-compliance with the provision of section 167(2) of CRPC is the question which we are confronted. In our view, grant of sanction is nowhere contemplated under section 167. What the said section contemplates is the completion of investigation in respect of different types of cases within the stipulated period and the right of the accused to be released on bail on the failure of the investigator to do so. But once the charge sheet was filed, such right came to an end and the accused would be entitled to pay for regular bail on merit. He now can pay for regular bail on merit. Once charge sheet has been filed, he can avail the provision of regular bail. Now, Lordship, para 48. The charge sheet is nothing but a final report of police officer under section so and so. Section 172 of the code provides that on completion of investigation, the police officer investigating into a cognizable offence shall submit a report. The report must be in the form prescribed by the state government, stating herein the names of all the criteria under section 173. It has been stated. This is a report. This report is an intimation to the magistrate that upon investigation into a cognizable offence, the investigating officer has been able to procure sufficient evidence for the court to inquire into the offence and the necessary information is being sent to the court. In fact, the report under section 173(2) of the CRPC purports to be an opinion of the investigating officer that as far as he is concerned, he has been able to procure sufficient material for the trial of the accused by the court. The report is complete if it is accompanied with all the documents and statement of witnesses as required by section 175 of CRPC. Here also, Lordship, all the documents, required documents and statement of witness we have appended with the charge sheet. So it is a complete report against this accused person. So he cannot be entitled for default bail, Lordship. In the present case, the investigation for the complainant applicant was complete at the time the first charge sheet was filed, as regard the offence mentioned in the FIR on Iman. At the time of first charge sheet, there was sufficient material on record for the applicant, such a statement of eyewitness and other material evidence collected and placed on record. Mere non-filing of FSL report is not sufficient to conclude that charge sheet filed in the present case was not incomplete. The said report can be filed by way of supplementary charge sheet. In any case, the case of the prosecution is preliminarily based on the eyewitness account of the company. The FSL report, if any, would be corroborative piece of evidence at any point, as pointed out herein above. Even after the filing of the charge sheet, further investigation can be continued under section 2. The opinion of the expert can always be filed before the trial court by way of supplementary charge sheet. It is further pertinent to note that in the present case, the learned trial court had taken cognizance after the charge sheet was filed, and the said order was not challenged by the petition. Same footing, Lordship. Now, para 34, now an investigation would be complete if the investigating officer is able to gather all the facts, information and evidence as also is available to the identity, the accused, and the requirement under subclause A to D are complied with in respect of the content of report. But subsection 8 of section 170, which begins with non-obstante clause with a deeming provision, interwoven permits further investigation. This is the further investigation with regard to the further investigation. Here also, Lordship, same footing, Lordship. They have not challenged the order of taking cognizance, and the charge sheet has been filed with all the required document as contemplated under section 173 of CRPC. Therefore, it's a complete charge sheet against this accused and is not entitled for default bail. That's my
Lordship, that complete charge sheet against these accused. And Lordship,
okay, I have heard both of you.
Only thing is the 173(8) is a statutory right, Lord. So that leave is not required. The moment the IO gives that note, itself shows that the investigation is pending against the other accused was named in the FIR note. And the repeated seeking of extension of time before the learned court by filing petition. Why the IO is required to do that? Because otherwise he is entitled to 173(8) to keep the further investigation going. So conduct of the IO subsequent shows that the investigation is going on with respect to other accused person. My humble submission is that, Lordship, the IO, while submitting the charge sheet, Lordship, his language is clear. The role of the other accused person named in the FIR was lordship yet to be asserted in lordship. And subsequent filing of the petition before a court below, seeking extension of time, shows that his investigation was still going on. And the judgment which my learned friend has now cited is pertains to only FSL report. FSL report was awaited. Their lordship, that entire case is defined lordship. And lordship, as your lordship, in the case of lordship Orup Deka.
No, you have made those submissions.
Observe the explicit language of the higher lordship.
Okay.
That is my humble submission.
In item number, there is a connected matter.
Yes, 31.
You have any other submission? You are placed similarly to the
Similarly,
president.
my lord, no, he's not claiming default bail. Also,
No, I am not claiming default bail because, my lord, we have filed a default bail application before the learned my lord session judge, my lord. In that order, my lord.
Before that,
My lord.
heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. M. Haloy, learned special public prosecutor for CBI. Let this matter be listed on 20th November for delivery of order.
Yes.
On Monday, I will pass out.
I'll furnish the judgment. Copy of
Today.
Lordship today.
In the already lordship 439 regular bill.
Okay, that I have already put.
Yes.
In item number, connected
number-
matter is there one. Item number
31, my lord.
31.
31, my lord, I am only on 439. The petitioner, same facts,
This
same
was
FIR,
item
my lord.
number 50. Okay. In 31, you have any submission?
Lordship, investigation with regard to the other cases is going on, is behind the bar, admittedly, we have no doubt. But Lordship, it is a very sensitive case, Lordship. Investigation, he may hamper with the evidence of the witnesses, and he is one of
Is
the.
scanned copy of case record is there.
Lordship, I have been the case diary.
Case diary is there.
I've got the case diary.
I'll pass your orders with
My lord, subject to my learned friend, my lord, he says that, my lord, it is serious, my lord, offense, my lord. My lord, read the FIR, my lord, what
No,
is the
this
serious
is not,
allegation, my lord?
analogous
no,
cases, sir.
let it be fixed along with that matter on
Delivery order.
delivery of order.
Because, my lord, I am not for the default order, my lord,
Understood.
because we have approached the learned session judge, my lord. In session judge, my lord, they observed that charges has already been submitted. He has clarified, my lord, the learned session judge. That is why I am not before your lordship for default.
Permitted.
Heard Mr.
Not
T.K.
permitted.
Bhuya. T.K. Bhuya, learned counsel for the petitioner. Also heard Mr. M. Haloy, learned special public prosecutor, CBI. Let this matter be listed for delivery of orders on 20/11/2020.
I'm
Since
declaring.
both cases are related,
My lord.
connected on the same day, I will
My lord, my lord.
Hello.
In the meantime, I will produce the order, my lord. It will, my lord, perhaps, my lord, help this honorable court. Because
The finding of the session judge is that charge has been filed.
In the meanwhile, what?
This order, my lord, my bail rejection order by the learned session judge, my lord. There, my lord, they have submitted that.
You have not.
I am not on default bail.
No. What is your submission?
My submission is that, my lord, I am not paying the default
That I
bail
have understood.
because
No, that I have understood.
before this session judge, my lord, they have admitted that charge sheet has already been submitted. If charge sheet submitted, my lord, I am entitled for regular bail period of detention, my lord. If my lord not, my lord, then let them commit the case, my lord.
Length of
They
detention-
cannot because for other accused, my lord, they have not submitted charge sheet, my lord. For their default, my lord, I may not be suffered, my lord.
Yes.
Length of detention cannot be a ground for bail.
That I will satisfy, my lord.
Length of detention, Lordship, cannot be a ground for bail, and severity of punishment and severity of offense and Lordship.
My lord, CBI, my lord, the CBI is not,
Criteria has
not
to
calling
be-
for heaven, my lord.
Has to be looked into, Lordship, before.
Obliged.
On 20th. of
20,
now.
my lord.
Monday, wait till Monday.
Lordship, shall I keep the CD?
CD, keep it till 20th. I may have to peruse it.
Item number 51.
Ten copy of LCR was called for, my lord.
এই দুটা চেম্বাৰত PRO চেম্বাৰত Scan copy of LCR was also. Has it arrived? Okay. Yes. Yes, well, FIR is at page 9, man. No, the trial is going on. Trial is going on, man. Charge is yet to be framed. You are behind the bar since? Since 14-2. This is an NDPS matter? No, no, Malad. This is a case under section 302, 664A, Malad. So how many days you are behind the bar? Malad, 9 months. All other accused are on bail, Malad, or access to all other accused are, all are similarly situated accused persons, Malad, all are on bail. Even one accused is granted anticipatory bail by this honorable court, Malad. That is, order is at 48, Malad. So why your bail prayer was rejected? Rejected, my lord. Why rejected? It is very difficult to say. Page number 37 of this application, my lord. Allegation in the charge. Page number 37. No, no. You have approached trial court. Yes, my lord. Where is the rejection order? Rejection order, my lord, is at page number 48. Oh, 51. 51. Your name is Pranab Ronghang. Charges are yet to be framed. Yet to be framed, my lord. And my lord, in this case, LCR has direct, my lord, there is no direct evidence in the entire case. Only circumstantial evidence, that too not directly. Here, my lord, as per postmortem report, death is due to antemortem drowning. But allegation and in the statute is that my lord, murder thereafter thrown the body into the river. So there is no sign of injury as per postmortem report, my lord. There is no direct evidence, and my lord, there is no direct witnesses, my lord, there is no. When the charge sheet was laid? Charge sheet was laid, my lord. When the case was committed to the court of state? The date of committal, my lord. I have not annexed that order, my lord. Charge sheet was filed on
16/10/22.
Yes, 16/10. When it
22.
was when it was committed?
Committal order, that is the not on it, no?
I want to know since when you are waiting for your trial to come. There are 52 numbers of witnesses, my lord. Trial will take long. Okay. 28 6, my lord. Close committed. 28 6. They are in the LCR, my lord. 28. And your name is Pranab Ronghang. Pranab Ronghang. Yes. Other accused persons, Ajay Kalita, Banti. Other Kalita is not granted bail. All other are granted bail. Yes.
Your lordship, charge yet to be framed, my lord. So they may take defense, my lord, here at the time of framing.
No. Question before us is whether to keep them under detention or not.
The detention, my lord, that
Why they are required to be detained.
charge sheet already submitted. So, my lord, now evidence will prove the case, my lord.
No, whether their detention is required.
Detain-
Unless you are apprehending that they will flee the course of justice or they will threaten the witnesses. What is the purpose of keeping them behind the bar?
It's true, my lord. But at this stage, my lord, that investigation is over. That some material is against him, my lord, that he has been arrested and now he is behind
No,
the bar.
materials are therefore are against them. Therefore, charge sheet has been laid.
My lord, my lord.
How many days? 9 months? Exact dates? Exact days.
For death of arrest is 14/2, my lord.
That to
Calculate. Heard Mr. U. Berman, learned counsel for the petitioner. Also heard Mr. B. Gogoi, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Pranab Ranghang alias Pranab Ranghang, who has been detained behind the bar since 14/2/2023, within brackets since last dash dates. You find it out in Google.
Yes, my lord. 274 days.
274 days since last 274 days. In connection with sessions case number 106/2023. Pending before the Court of Learned Additional Sessions Judge number 1, Kamrup Metro. Stop. Where is the charge sheet?
Charge sheet is at, my lord, page number 15. 15. It starts from 15.
Learned counsel for the petitioner has submitted that the petitioner is facing trial in sessions case number 106/2023, which is pending in the Court of Learned Additional Sessions Judge number 1, along with how many other co-accused?
Total 9 numbers of accused. Total accused.
Along with 8 other co-accused persons. And he has been detained behind the bar since more than 9 months. It is submitted by learned counsel for the petitioner that though the case against the present petitioner has been committed to the Sessions Court on 28/6/2023. However, charges are yet to be framed in the said case. It is further submitted by learned counsel for the petitioner that apart from the present petitioner and one other co-accused, namely Ajay Kalita, all other co-accused persons are already on bail. Hence, as per submission of learned, hence the petitioner has all other accused persons are on bail. Stop. Learned counsel for the petitioner has also submitted that the petitioner is You will face trial
Yes, my lord.
from Boithalangsu.
He is residing at Guwahati, my lord, present. Sonapur.
Where is his address? The petitioner, learned counsel for the petitioner
His mother is also an accused, my lord. She is also granted to him.
has submitted that the petitioner is ready to face trial along with the other co-accused person. And for the same, any condition may be imposed by this court. Stop. On the other hand, learned additional public prosecutor submits that you are otherwise opposing.
Yes, opposing, I'm opposing, my.
Learned additional public prosecutor has opposed the grant of bail to the present petitioner on the ground that one of the offense involved in this case is under section 302 of the Indian Penal Code, and there are sufficient materials against the present petitioner in the case that sufficient materials against the present petitioner. It is further submitted that the petitioner had also moved for bail before learned trial court, which was rejected by the trial court on the ground that the present petitioner and co-accused Ajay Kalita had taken active role in pre-planning for committing the alleged offense. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the scanned copy of the case record of sessions case number 106/23, which was called for in connection with this case. It appears from record that out of the 9 accused against whom charge sheet has been laid in this case, 7 are already released on bail. It also appears from record that the petitioner has been languishing behind the bar since last 16/10, since last 14 to 2023, and there is no specific plea on the part of prosecution side that the present petitioner may flee the courts of justice, or that he may intimidate any of the listed witnesses of the case. It also appears that there are total, how many witnesses? 52. There are total, confirm it, how many listed witnesses are there?
Yes, 52 listed.
There are total 52 listed witnesses. Witnesses listed in the charge sheet in column number 6 of the state charge sheet. And it would naturally take a long time for culmination of the trial. And there seems to be no justification in keeping the present petitioner behind the bar when most of the co-accused have already been granted bail. Stop. In view of above, the petitioner named it Pranab Ronghang alias Pranab Ronghang is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned additional session judge number 1, Kamrup Metro, with following condition. Number 1, the petitioner shall appear before the learned trial court regularly as and when so required by the learned trial court, and shall cooperate with the and shall cooperate in the trial. The number 2, the petitioner shall not directly or indirectly make any inducement, threat, or promise to any of the listed witnesses of the case so as to dissuade them from disclosing the fact in the trial before the learned trial court. Number 3, the learned trial court may impose any additional condition for bail if it deems fit to do so. With above observation, this bail application is hereby dismissed.
Bail hearing item number 33.
Yes, here's statute submitted, my lord. My lord, may I pray before Lordship?
This is an anticipatory bail.
My lord. Actually, my lord, a number of dates taken by the IU regarding this case.
No, have you appeared before IO?
Yes, my lord.
After after getting entry
yes,
interim bail, have you appeared?
appeared.
This is item number
Item number 33.
33.
Okay. A number of dates, the IU are not able to submit the CD. Since from 25 5 to till 29 9
Okay.
1
Lord
9.
Mr. J.I. Boardmere.
My lord, I Mr. SZB,
What is your name?
Mr. SZB.
Lord Mr. S.
ZB Atlas.
Aklas. SZB Aklas, Learned Counsel for Petitioner. Also heard Mr. B.B. Gogoi, Learned Additional Public Prosecutor, who submits that though the case diary was called for in this case, however, in the meanwhile, charge sheet has been laid by the investigating officer bearing charge sheet number
474/23 dated 28/23.
Stop. Learned counsel for the petitioner has submitted that the petitioner, how many petitioners are there?
4 petitions.
The petitioners, namely Lutfur Rahman, alias Sikdar Lutfur Rahman. Number 2, Ainul Haq Mullah. Number 3, Omar Ali and Maznud Rahman, alias Mazuruddin Ahmed, were allowed to go on interim bail by this court by order dated 25/5/2023, and in pursuant to the directions of this court, all the above petitioners have appeared before the investigating officer and have cooperated in investigation. Stop. In view of the laying of the charge sheet, as well as in view of the fact that the above named petitioners have cooperated with the investigating officer in fair completion of the investigation, the interim, the order dated 25/5/2023, by which the above named petitioners were granted interim anticipatory bail, is hereby made absolute with conditions number 2, 3, and 4 attached to the said order remaining intact. With this observation, the instant anticipatory bail application is thereby disposed of.
Most of like
34.
34
May I please, Your Lord?
diary not received, my lord. They are in interim.
Your own interim.
Yes.
Yes.
Heard Miss
Yes, Father.
Heard Miss S. Bhagavati, Learned Counsel for the petitioner. Also heard Mr. B.B. Gogoi, Learned Additional Public Prosecutor, who submits that that though the case diary was called for, however, same has not yet been received, and prays for some more time for producing the same. The prayer is allowed. Let this
Interim
case be,
expected.
7/12.
this case be again listed on 7/12. 7/12. Interim order shall continue. We are rising earlier today.
Please, Your Lordship, I am sorry to interrupt, my lord. In item 53, my lord, CD is also available. I am not interim, my lord. So if possible, my lord, Friday, my lord, this Friday, my lord.
Court master will give dates.
My lord,
No, just a minute. In all leftover matter, this matter could not be taken up for hearing due to paucity of time. Let this matter be listed on dash. Dash will be filled up by court master according to their convenience. And wherever the interim order is there, interim shall continue.
Problem.